Cannon Beach TV is up live now. I always like to start the meetings by talking about Cannon Beach Bulletin, because if you can't get enough at Cannon Beach TV, you can get more than enough online to read the Cannon Beach Bulletin. Rusty, would you pull it up online just to show everyone here tonight and watching on Cannon Beach TV how easy it is to see this bulletin. Great place to keep up on what's going on in the city. City Hall groundbreaking. To me, we used to have a formal meeting place. It's gone now. It's being reconstructed. Not that the groundbreaking. You can't get enough of Cannon Beach Planning Commission TV. We've got more than enough with the City Council work session, Parks and Community, Budget Committee, Design Review Board. That and more for your evening entertainment. More seriously, and our city manager, I guess, is here tonight for this special group of planning commissioners to talk about the here it is. Code of conduct. Thank you. I don't even know what to call it. I'm so afraid it's new. Code of conduct, fun stuff in the bulletin, among other things. It's a great way to keep up on what's going on in the city, so you don't end up in front of what the heck happened. How did we? Let's talk about where we are tonight. We have an agenda in front of us. It's going to be slightly amended. I won't say former yet, because it's just so hard to say goodbye, Bill, but our almost former council is here tonight to say goodbye to us and to give us an update on some events, some items that were in front of us and are now moving through the court system. So we'll move that if everybody's okay to the top of the meeting, so Bill doesn't have to stay through the whole thing, although I know he's just dying to do that.
Yeah,
and
you know how much I miss being able to come down there and join you guys.
So if that's okay with everybody and the agenda stays the same as it is, we'll start out with Bill. Does that sound good? Okay. Let's do that. We'll put you even ahead of the minutes. That's how important you are, Bill.
Thank you. I do appreciate it. I guess I'll start out with the business and get to the other part at the end. And what I'd been asked to do is provide an update about the Roberts appeal of their house application. And Missy Ryan, who has taken over for me, was on the Land Use Board of Appeals that decided that decision. So that's on appeal. So she can't really participate and is really going to have to recuse from doing those things. Our colleague, Carrie Richter, will be handling the appeal as it goes forward. You know her from previous times down here, and so it's in her capable hands. But just to give you an update, it has been something that's been hanging around, but it's been a long time since it's been at the Planning Commission. Because if you remember, what happened was staff made a decision back in 2022 that was appealed to LUBA, and LUBA remanded it back to the city in, I believe it was March of 2023. And at that point, the city council said it's going to get appealed to us anyway. We're just going to go ahead and make the decision on it. And so in August of 2023, they denied the application for a number of different reasons. And both parties appealed it to LUBA. And LUBA made its decision in April of 2024. And they remanded the decision. They generally upheld some things, but ultimately remanded for a variety of reasons. Most importantly, what they said is we didn't really the city did not appropriately deal with a requirement to deal with trees, that the removal of trees and how that would affect things. And so that may be coming back, but otherwise, that's what LUBA did, and that was in April of 2024. Again, both sides appealed to the Court of Appeals, making a variety of different arguments. And at the Court of Appeals, they issued their decision in September of 2024. And the Court of Appeals said, when it was before the city did not apply its geologic overlay zone requirements because they weren't clear and objective. It's pretty, I don't think anybody can say they're clear and objective. But what the neighbors said was, well, yes, you can apply them against the house, but you can apply them on development of the roadway. And the Court of Appeals agreed with that and sent it back to LUBA saying, LUBA, what does this mean, essentially? And at that point, the Roberts appealed it to the Supreme Court. And the Supreme Court accepted review in March of this year. So just, about 2 months ago, they said, we're going to take it up. And, it's somewhat unusual. The Supreme Court basically only takes about 1 in every 10 cases get appealed to it, and probably not even that many when it comes to land use. But what it does do is slow things down and adds another layer. The parties are now in the briefing process, so filing briefs, their position. Oral argument is set for sometime in September. The exact date hasn't been set, but they'll be argued in September of 2025. And I would not expect a decision any earlier than mid-2026 and more likely towards the end of 2026, early 2027. So that's the timing and where we are on that. If, hopefully that wasn't too confusing. Happy to answer any questions or clarify things if I made a hash of what I was explaining.
Any questions? Well, that's a great update. Obviously, it was a long time ago we looked at that. We're always looking to see, where we can improve our process. So having an idea of, just how far these can go. And this is the first one I've seen go to the Supreme Court. It makes sense given the complexity of that case before.
Most of the cases I deal with will go to LUBA and that's it. Occasionally you get to the Court of Appeals. Supreme Court, I think I've been there 3 or 4 times in almost 30 years. And so it is really unusual, but the timeline just gets really, really extenuated, just gets really lengthy.
Well, thank you for that update.
Of course.
And along that line, certainly what you just outlined for us, but many, many other decisions in front of us were complicated in a lot of different ways that I really appreciate over the years, all the help you gave this body and certainly the city navigating through some of those decisions that went well into I don't think we ever made it to the next day, but we were really close a couple of times trying to navigate through that stuff. And it was really nice to have you there when we got stuck or we just didn't know the answer. So really appreciate all you've done in helping us and the city in general.
Of course. And I just want to give props to you because you're the people who actually have to deal with these complex, weighty things where you're really weighing things against other people. And, the pay isn't that so good for spending all the time reading this stuff and sitting in that room, having people upset with you and telling you you can't do anything. And you're the backbone of how the system works. And so I just really want to express my admiration and gratitude for you guys stepping up. And, that it's been an honor and privilege to work with Cannon Beach. I went back as I was looking through retirement, and actually the very first Court of Appeals case I had involved David Holland's attempt to do a subdivision in Cannon Beach back in 2001. And the very last Court of Appeals decision I have is the Roberts one. So, Cannon Beach has sort of bookended my career. And so you guys have been important to me. And I look forward to being able to go down to Cannon Beach and enjoy it and not go, oh, geez, that guy. Yeah, we got to deal with that. So.
We're joining you on that beach. Well,
Yes.
thanks again, Bill. Really
Thank you. I really appreciate it. I wouldn't feel comfortable retiring unless I knew you're in good hands with both Missy and Carrie here to help you out as you wrestle your way through other ones.
Now we can say you're retired from us, that we've had this meeting. Thank you for your last time on Zoom with us. Missy, we'll be leaning on you tonight later, I'm sure.
Thanks so much, Bill.
Thank you again.
So with that in mind, some of these cases can get pretty complicated. We act as a quasi-judicial body in a lot of these decisions. We are appointed, we're not elected by the city council. We act as this body for you, the people, citizens of Cannon Beach, or the people who own property here, trying to navigate through this complicated code we have. And it's not just Cannon Beach, it's complicated. And the world we're in, frankly, it's just, a lot of opinions and things are changing. So we do our best. You may not always agree with us. And that's why we have a process for appeals and that sort of thing. We'll talk a little bit more about that as we navigate into the specific items we're talking about here tonight. We'll probably take a break at about an hour and a half. There's a restroom right here down this very short hallway. To the left, there's water you know, I know there's water or cups, I don't want people drinking. There is, we can, if someone really gets thirsty, we'll figure something out. I took the chair, I wanted 7 people, we have equal voting rights, we will, discuss your items as we come along. I'll be navigating the meeting, if you have something to say, you'll, I guess it's right there, this is voting. This is a new space for us as City Hall, so I'm still getting used to where I'm talking. If you're coming up, just, I'll recognize you, then you can come up, give me your name, your mailing address, and then at one point we'll close the meeting, then we can take no more testimony, the way the law is written, and we will discuss among ourselves what we've heard, what we've read, and make a decision. I'm just looking at what we have in front of us here tonight. If you don't agree with the decision, you have a right of appeal, you have 20 days to go to make an appeal to city council, after our decision. Okay, go through a couple little, pieces of this we have to get through, and then we'll jump right in. Consideration of the minutes for the, our April 24th meeting. You know what, actually, I kind of ran through that agenda a little too quickly, I didn't really formally, I better button it up here a little bit. May I have a motion to approve the agenda for this evening? Okay, may I have a second? All right, any discussion? Tessa, will you call the roll, please?
Commissioner Sinclair,
Yes.
Commissioner Bates,
Yes.
Commissioner Orloff,
Yes.
Commissioner Moritz. Yes. Commissioner Matusek,
Yes.
Commissioner Wade,
Yes.
Chair Newton.
Yes, agenda is approved. A couple of our, commissioners are on my, you're good at coming on, at different points in the okay, moving to the minutes. Are there any amendments to the minutes from our April 24th, 2025 minutes? Okay, if there are no amendments, may I have a motion to approve those minutes? I move to approve the minutes. Second,
I'll second.
any further discussion? That's what we call the roll.
Commissioner Matusek,
Yes.
Commissioner Wade,
Yes.
Commissioner Bates,
Yes.
Commissioner Sinclair,
Yes.
Commissioner Moritz. Yes. Commissioner Orloff,
Yes.
Chair Newton.
Yes. Minutes are approved. We now have, our city manager is here to speak to the code of conduct. Come on down for us.
Like the record, Bruce St. Dennis, City Manager. You folks have had the information regarding the code of conduct for a while. And you generally are well behaved, so, I know you got a busy schedule, so why don't I just go to questions if we have any? Unless you want me to read it.
Let's have Friday. Very funny, actually. There was a lively discussion around free speech versus, hindering, city employees' ability to get their job done. We have had those discussions in this body as well. I would be curious your take on where that discussion ended with the people who ultimately are giving us the direction on how we're acting. Kind of a tough question to throw at you, I know, but it's definitely, in the room on that.
Are you talking about from the council?
From the council.
I would prefer that, give me some time to bring back an answer on that,
Okay.
because I'd rather work through the attorney than give you an interpretation.
Okay.
So, send you an email or something.
That sounds good, yeah, there was back and forth in particular, just so that the, who's ever addressing it, I can't remember, I don't think it was being missing, so I won't put you on the spot. Around, language around elasticity, if I remember right, elasticity versus, what was those words? I'm thinking uncertainty, but that wasn't, basically it wasn't clear what it meant to hamper a city employee's ability to get their job done. And so the language was a little broad, was what I took away from the meeting, the conversation around. And, I think it'd be helpful for us to have some kind of understanding of where they ended up on that, just so we don't end up tripping over that.
I'll get you that.
That'd be helpful, yeah. Anything else? No. Everybody online? All right.
All right, thank you.
Thanks, Bruce. Okay, Bill, I guess I went out of order already, I'm already way off here. So we'll move to public comment. At this time, if somebody or anybody has any sort of comment that they believe is within the purview of the planning commission, is not related to an item you're here tonight to speak to, we'll give you the opportunity to speak to that. But just something you think that the planning commission ought to consider, as part of the city's operation through planning and zoning, we'd love to hear from you. We keep it to 3 minutes. Anybody here tonight would like to speak to that? Okay, anybody online? I'm interested. Well, great. Okay, we'll move on. Our first item tonight is this quasi-judicial, concept that I'm talking about with acting as, dare I say judge and jury? We're gonna do our best to look at the facts in front of us as you present them, as we interpret them through the code. And we'll render a decision after we've considered everything in front of us. This is a continuation of AA 2501, Doug and Superdell for their administrative appeal of the city's denial of tree removal permit. Doug and Superdell for an administrative appeal of the city's denial of tree removal permit at 379 Elk Run Avenue. The appeal will be reviewed pursuant to the Cannon Beach Municipal Code section 17.1 review request for review. Does anyone object to the jurisdiction of the planning commission to hear this matter tonight? Does any commission member believe he or she has a conflict of interest or a personal bias?
I had courtesy recusal last time, so I would pull myself off at this time.
Great. Has any commission member had any context from made of site visits? Site visits. Do you guys want to revisit the staff report, or is there any?
Only if anyone has any specific questions, I think, and anyone can correct me if I'm wrong on this, but, I believe where we left it last time was the Fredel's had some questions. There was some discussion in terms of, having the ability for, the city arborist Jeff Gearhart to be here this evening, which he's attended, so thank you. And Mr. Fredel had provided some questions which you have seen. And so at this point in time, that was my understanding, was we wanted those questions and we wanted to have some discussions prior to making a formal decision.
Any additional correspondence that has come in since, say, noon?
No.
Right. Oh, the note from you.
Good evening. Unfortunately, I can't be there tonight. I've got a mobility restriction keeping me at home, but no new correspondence has come in.
Great, thank you. All right, we'll move to public testimony. The pertinent criteria to be considered are noted in the city staff reports and listed on the criteria sheet on the main page of the city's website. Testimony, arguments, and evidence must be directed toward those criteria or other criteria in the comprehensive plan and municipal code which the person testifying believes apply to the decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to an issue precludes appeal based on that issue. Persons who testify shall first receive recognition from the chair, state their full name and mailing address, and if appearing in a representative capacity, identify whom they represent. It's a presentation by the author. We can go.
Doug Fredel, 168 Capella Court, Issaquah, Washington. So there's no presentation. At the last meeting, there was interest in asking questions of the arborists that we had hired to do the report that the city had required. And so Joe Birch, our arborist, is here if you'd like to ask him questions.
Okay. We have our normal process that we run through. It seems that we might want to amend that just a little bit to allow a wider discussion. We had some questions around for the city's arborists. That might lead to questions for the applicant's arborists who may generate some questions.
We start with city arbors.
I'm thinking maybe we maybe we amend the process a little bit and we could start with the others. With some of the questions that we have, because it seems like we're just kind of picking up right where we left off, and I don't want to put the record, and I don't want to get locked into this process that will hamper us a little bit. Does that make sense to everybody? I assume. Online sound good, guys?
Yep.
I'm not, all right, sounds good. So why don't we start with our city's arborists, and we can ask questions there, and then maybe direct questions to the applicant and producer. The arborists. Mr. Hill, do you want to come forward, please? Thank you. Thank you for being here tonight. All right, appreciate you here. That's it.
I am Jeff Gerhardt, 10570 Meadowlark Lane, Manzanita, City Arborist. And this is in regard to 379 Elk Run and a Sitka spruce, 2 Sitka spruce removals. One that's 30 inches in diameter and a smaller one that's more like 20 inches in diameter. What kind of questions do you have? You want me to give just kind of an overview of my assessment?
It'd be super if you start with an overview.
Okay. So the most recent request to remove these trees, this is the second request. It was requested they be removed when there was going to be an addition in close proximity to these trees. And that was back in 2000, 5 years ago. And I requested that instead of removing the trees be retained and the foundation addition be amended to keep these trees. And the whole reason I've kind of had this emphasis to preserve these trees is the grove that they are a part of. It's a heavily forested neighborhood, mature spruce trees that have grown up in a grove, so they share a canopy and they share a root system. So I find it very important that we maintain a safe, healthy canopy. And my concern with removing the larger of these 2 trees is that its removal will weaken the structure of adjacent trees in this grove. Kind of a domino effect. I kind of think of the bigger tree as what I would call like a keystone tree. That by it being there, it supports other trees neighboring. And if it were to be removed, which Joe Birch alluded to in his report, there's a smaller spruce tree that's not as close to this residence that was also included in the removal. So kind of a domino. If we're gonna take this big one near the house, we better take this smaller one next to it. And then on my site visit for this more recent removal request, I noticed that there's probably gonna be a 3rd tree that would also be weakened by the removal of this tree. And that tree, it's not a great photograph because it's kind of a monotone sky, but this is kind of an overview of the grove. We have this central kind of keystone tree I'm alluding to, this larger Sitka spruce. There is and also a large hemlock nearby, that if this tree is removed, this tree is going to be more susceptible to falling over. So out of, wanting to protect Doug and his home.
Mr. Governor, sorry to interrupt you. Yeah, if you could direct your,
Okay,
comments to us, that would be really.
certainly.
Thank you.
So
We may open it up to a different sort of format, but generally it's just that. Fair, thank you.
I'll continue. So in order to protect Doug's residents and other homes in the neighborhood, I wanted to see this kind of keystone tree remain as it, supports other trees in unison. That was kind of my bias in preserving that tree, retaining that tree, was to keep a safe grove in the community, in the neighborhood.
Okay.
So you want me to keep going? I got Doug's Friedel questions, and I answered them. I could go through them and give my answers to the questions.
I think that might be helpful.
Go ahead, I'm asking a question. So that was your assessment at the time before construction, that keeping the trees was important.
Yeah,
And it continues to be your assessment now.
5 years later, yeah.
Right, okay. Did you find anything wrong with those trees? I mean, were
Not structurally, not in terms of, I didn't see any signs of decay. Or, there is some insect presence, there's a lot of spruce aphid in the neighborhood.
Yeah.
So there's some thinner canopies, but nothing structurally that made me think this tree. I didn't see any signs of rock or soil heaving.
as those trees were oriented, there was an A and B, and I just prefer to call them a larger tree and a smaller tree. Which one was closer to the house, the larger or the smaller? Do you recall?
The larger trees closer.
So, the Friedel came in, to have the tree removed because they felt like it was a safety hazard, which puts you in a position to evaluate the tree. She found healthy. You also had to look at whether there's any reasonably foreseeable chance that the tree might form properly. And you did that. I guess your intention, your decision would have been made on blowover and stuff like that, and you just felt like it was probably not a significant risk, given the location of the trees.
At this time, correct. There definitely of note is the fact that since my original inspection,
Yeah.
there has been an addition. And now the tree is in very close proximity to the addition.
All right,
I would say I went up and measured it, actually. Step close to me. Right now, the tree is 8 inches from the root.
right,
And at some point, the tree is gonna make contact with the root.
all right,
I took an increment borer, I made a small incision, drilled into the tree. And I established that the tree is growing at about a rate of 3/8 of an inch a year. So in 15 years, that tree roughly will come and touch the house. In high winds, there will be leveraging forces on the canopy, so that distance. So maybe there's only more like 10 or 12 years. If the top of the tree is really flexing in the wind, this lower stem is not gonna be moving near as much. But I would say within 10 to 12 years, the tree will contact the side of the house. So right there is. I'm trying to think of the right wording, a foreseeable danger. So that was one of the questions, the first question. The city code allows property owners to remove trees that are foreseeable danger. Does the city arborist believe that these trees qualify as foreseeable danger? So at some point, yes, so it's foreseeable, but I felt if the tree were to be removed, it's gonna present an immediate danger in another tree specifically.
Based on that, boring you did. Or maybe based on your observations, I don't know if you came out after the structure was built or you will make initial recommendations before it was built. In either case, do you have an estimate of how far the tree was away from that, fascia at the time of construction or thereabouts? Are you able to make an estimate as to roughly what it would have been?
Yeah, so if it was 5 years ago, it's roughly been growing 3/8 inch a year. So it's probably closed that gap. It was probably, let's say it was 10 inches 5 years ago, now it's at 8. Just as an estimate.
that's why I get confused, and I'm not, I just wanna get clarity on it. I thought you went out in 2020 project. You inspected, you knew at the time there was gonna be construction on it. I had no idea what it was gonna be, but, Is that
Yeah,
correct?
that's correct.
So they were just saying there's gonna be construction, you know, we need to take this tree out, it's, save it. What was the response to that?
Well, I had no idea the house was gonna be built so close to the tree,
Mm-hmm.
so. You know, to have returned, now 5 years later, there's a house 8 inches from the tree. It's a little shocking that it's been built so close.
You weren't given any plans that showed the location of the addition and,
You know, that wasn't. I think I reviewed the site when there was some tree protection fencing up. Which I have a photo of. This was before, you'd like to see?
yeah,
This was before the addition was created, so there were, this is the large tree. Smaller tree, 30 inch.
Now, what are the buffers on that tree protection thing? How far around, what's the circumference around each tree that you've already cited?
Well, ideally it would be to the drip line, but then you can kind of, you know, squish it depending on how you need it. So what made this addition successful when I signed off on it was that, they were gonna use post and pier foundation. So not just a traditional stem wall with an excavation, because if there would have been an excavation, I would have taken up too many roots.
So at some point you were able to sign off on plans. But that didn't have to do with the distance from the tree, it had more to do with the foundation that was on the ground with the affected root system.
Do the roots grow faster than the base of the tree itself? The roots may be affecting the foundation right now, as I understand it. Are the roots going to grow faster than the trunk?
That's a good question. I did not do any examining on the roots or any, you know, I didn't do any increment boring on roots, but as a rule of thumb, I would think the fastest growing portion of the tree is gonna be the main stem. Not that the roots are far behind, but the roots, individual roots are kind of more like limbs. So maybe it's not putting on as much dirt on a yearly basis. So I would think roots would grow slower than the stem.
I know one of the questions that's on your list was about high wind, shear, whether being next to a structure makes it more dangerous in high winds, that it's gonna be some kind of snapping effect. Can you talk a little bit about what happens during a storm if a tree is near a structure and whether that actually makes it more likely the tree will snap or not?
So you have, the tree canopy. You have leveraging forces, the canopy is gonna work like a sail. So as the force is put on that leveraging arm, you're creating a string and a force. You do have something that the tree is in contact with that can create, you know, a place for the tree to fail. At this stage, and there's no contact with the house, so it's freestanding.
So even in a high wind situation, I'm wondering how much play there is at that point.
Right.
You know, is it 2 inches? I don't know what, you know, in a high wind, how much is that part of the trunk likely to shift?
At this stage, the roof line is about 15 feet.
Yeah.
We've got a 100-foot tall tree.
Okay.
In the highest of winds, if that canopy is swaying 20 feet out of plumb, it's really only gonna be moving maybe an inch, you know, or none at that, you know, very minimal.
So far down.
Yeah, the tree's gonna be absorbing that flex higher than canopy. But what I would propose is a thinning of the canopy to offset some of that leveraging force. That's called a wind sail reduction, not a topping, but to thin the crown to let more wind blow through the tree.
So then you conclude then, as I understand it, that at some point the tree may fail, but it's well into the future in your opinion. And it will have to be taken down then, but you wanted some trees to be planted now. In between, it sounded like the citrus spruce and the red cedar. To help that ground support the removal when the tree has to be taken down. Did I read that correctly?
You did, I didn't mention that in my report, I mean, that would be ideal. Based on what it's escalated into now, though, of sick, you know, I'm not so concerned anymore about replanting. But more ensuring that if that tree does get removed, that other trees are gonna be inspected and compensated. I don't want it to turn into a domino of tree removals.
Right.
Then now we remove this tree. So there's only one tree that's closed. When it comes down, another tree has to come down. And I'm thinking that a third tree is gonna become, you know, hazardous. So this keystone tree is really doing a good job to support the growth. So I kind of want there to be a bigger plan of, okay, if we do need to remove this tree in 10 years or now, whatever, that we have a plan on how to safely retain the rest of these trees in this grove.
And you put something like that, yeah.
Yeah,
That's fine.
oh yeah.
What is the mitigating option?
So, a thinning, a pruning,
Okay.
canopy reduction.
So you'd say either way, there should be canopy protection.
Yeah, and that's specifically to this third kind of hemlock. Not the best picture, but if this is a tree that's coming out, this is a very picture, and there's another secondary tree that has to be removed, there's a third hemlock, it's just gonna be kind of out here, getting separated from the grove. That needs some sort of compensation pruning. If not removal, but I feel like that's kind of an assessment to be made, maybe not by the city arbors. If, you know, maybe the property owner's arbors.
So pruning, and then I don't imagine planting where you thought those red cedars should go would be a bad thing in, both would.
Oh, yeah, I mean, I'm always a proponent of replanting.
How old would you say the tree is?
As a ballpark, I'd say it's around 80 years old.
And has it been pruned? Has the crown been pruned in the past? Could you tell?
It looks like it's had some pruning in the past, yeah.
Are there any other sections in the answers you gave that you think would be?
Yeah, let me make sure, because there's a lot of questions in here. Okay, there was a question. If I had a discrepancy with the tree hazard rating that the Friedels arborist gave it. So when a tree is assessed, there's a generic form that we use through the ISA, and you can kind of create a rating of how hazardous a tree is. So it's based on all these factors. And the rating was given a 9. And I would agree with that rating. And that rating is based on basically 3 items. You have the size of the tree, the target rating of what could that tree potentially hit, and the likelihood of failure. So if every rating gets a 1 to 4, and you add those up, you get a scale of 12 being most hazardous, 0 being no hazard. So if you have the likelihood of failure is a 4, the size of the part, the largest it could be 4, and then, the target high 4, so you get, that would how you attain a scale of 12. So this tree was given a 9, and I would agree with that. But basically, given that model, every tree in that neighborhood of 30 inches and bigger would attain that same scale. So pretty much all trees are inherently dangerous. You can't really give anything a 0 if it has the chance to fall. So just based on, the size of the tree and where they're located, they're gonna garner some sort of a hazard rating.
I tried to read that rating and it seemed to me you put respite on it. The lowest possible. I gave it a 1. Everybody else who gave it a high.
Right.
Now, the other arborist gave the risk a 2, and another that you gave it for a 3, and then the last a 4, but, you know. Good work, it's interesting work, but. How much does that risk the failure plan carry out, so it's. Is it a big factor in it, or do you just play it strictly by the numbers?
Oh, no, I think it's a totally organic thing and depends on the situation.
Yeah.
Mhm. Yeah, I think I'll leave it at that unless questions.
Number 8 question, so all the trees have internal voids at the base of the tree. Are those a result of just the way the tree grew, or is that a result of analysis from more?
Those voids are just, common root flares for that species. There's no sign of decay or, you know, perhaps it grew up on a nurse stump, and so the way the buttressing roots form, but there's no cavity there or sign of weakness.
Are those trees inherently more risky, they call them clothespin trees, right? Are they inherently more risky than those that have a single root?
I haven't really seen it firsthand. Yeah, I think trees kind of, you know, when they grow on that nurse stump, they kind of compensate and create stronger roots, so. And this is very low down to the grade, it's not elevated at all.
Ref, I had a quick question for you. When you went out and inspected the tree, was there any evidence that the tree trunk had in fact collided with the structure of the house? Did you tell at all?
None whatsoever.
Thank you.
Any other questions? Really appreciate you, answering the questions and all the hours there tonight. Are you okay hanging out?
Oh, sure. Yeah.
Okay, thanks very much.
Thank you.
So, how do we want to move ahead? Do we want to have the applicant come back? It might. Yeah, I think that's it. Maybe ask questions in real time, give them what we've heard. Yeah, I agree. Okay, so we'll come back to the applicant, and any of your representatives, your artists as well, will come in and present anything. Those are here.
Thanks. And I want to thank the city arborist for coming in and talking. That was very helpful. Okay. So, I'd like to have our arborist take a chat with you, and then I'd like to come back when he's done. Okay, feel free to ask questions. Sure.
I'm Joe Birch, certified arborist, been climbing trees here on the coast for 27 years. Can you get them started questions for me, or do you want me to tell you?
Do you disagree with anything there?
Not, well, mainly the removing of the one tree is gonna affect that whole grove. I took 10 trees out of there for the city about 10 years ago that were all hazardous trees. The rest of the grove's still fine and intact. If it was more on the windward side of the grove, I would lean more to agree with that, but being inside the grove, you know, where it's not gonna allow some trees that haven't been exposed to wind before to all of a sudden get new winds to them. So I would, my feelings are that if this tree's left alone, it's gonna contact the house. The roots right now might be damaged. Some of the pier pillars underneath are starting to lift to the side. I didn't excavate down there to see if the roots causing that or what. But that tree is gonna contact that house. So I don't understand why we don't get rid of it now instead of wait for it to contact the house and do damage.
How many years do you think we have before it actually contacts the house? And without the thinning, would that, how many years would that give us, or would that be effective in your opinion?
The thinning would help reduce the sway of the trunk. I would agree with Jeff that, you know, 10 to 15 years, you're gonna see some contact down there. but I wonder, does the city have the ability or have the authority to tell people to prune their trees? I mean, is that in code?
I don't know if it's in the code, but we do have the authority to deny the appeal. Yeah, so we're effectively giving them option, right? So, you know, if this were something that would go for an outstanding code, I think there would be conditions put on that. So I'm just saying, you know, yeah, we can.
That's
My opinion.
your opinion. Yeah. Other question?
Were you involved in the permitting process for this? Were you involved in the permitting process for the addition?
No, sir, I would not be.
And this is just to the council. I'm just having a hard time, well, understanding how the addition was approved, or the architect drew the plans to place the addition where they did. I mean, it seems counterintuitive for me to reward, and I'm not saying that the homeowners want the tree gone just to want the tree gone, but the tree has to go, which means another tree has to go, another tree has to go, because they chose to place the addition in this direction. It seems like some more creative design could have avoided this altogether. So, and maybe that was the city planning department approving this when they shouldn't have. I guess I don't know what happened there, but it's tough for me to say, let's take the tree down today, because in 10 years there will probably be contact with the tree. I mean, let's wait 8 years before we take the tree down. Lot can happen in 8 years. I'm just having that's my biggest struggle here.
We'll look at that as rather than have a discussion about that at this point, how we'll frame that is a concern of one of our members. It will be voiced between us when we discuss this, when we close the record, and there will not be the opportunity for you to respond to it. So that's on this commissioner's mind, Commissioner McKissick's mind. If you have thoughts on that concern, now is your opportunity to address any of the couple of points you brought up there to make clear for us your understanding or experience through the process and address this concern.
I mean, I've had issues in the past where things have been approved, you know, and then I've gone on site to do the work, and then after doing the work, I'm like, this isn't safe, we can't leave this here. And then we go back to, you know, jump through all the hoops again, we come back and then take the tree down later. So it seems like maybe there's not the best communication between the city with the planning department and the tree, you know, it seems like when I get on site, like that, just the communication wasn't there, because this should have been avoided. The instance I'm talking about was like a 52-inch tree that had a 10-foot tree protection zone around it. I mean, that's ludicrous. For a 52-inch tree, took almost the whole tree protection zone, or the root protection zone. But there was no, that wasn't gonna work in any world.
And again, my comment to you on that point is, because of the process we're in, you won't have a chance to respond to this had I not brought it up to you, so I want to make sure we're being fair. And you as a representative of the applicant, it's fair to ask this question. But the arborist said he didn't want the tree there. He said the tree should remain, and the structure was put in place anyway. So there was that concern could have been addressed before the structure was built, and we had the city arborist saying we need to save the tree for this canopy or for this grove. So there is a set of logic, because you knew the risks and you did it anyway. And then there's another set, and I'm not saying this is the case, there's another set that says you did it anyway, and you possibly thought, well, we'll just come back and get it down and we can consider the rest of the property. Can you talk to that at all? And the process was broken down?
I understand what you're saying. I can't really speak too much to that, because that was before I was called. I was called when the building was there and there's a tree there, so that's what I'm speaking to.
So the other comment by one of the commissioners was, why not wait 8 years and then take it down? Does that seem reasonable to you?
it seems risky because nobody's a fortune teller. A tree could fall over tomorrow, it could fall over, I mean, a tree last winter, 2 houses down, ripped off the side of the house in there. And I don't understand why roll the dice, why risk it, why wait when we know it's gonna come down in 10 years? Why even wait, why risk it? You know, you are rolling the dice, whether you know it or not, each time the wind blows, it could blow over. So.
But
in my mind-
isn't that true? Isn't that true of every tree on the planet? It could blow down at any time.
Absolutely, but if we have this, we're saying we have a timeline, we have a 10-year time frame where we know we're gonna have to take it down in 10 years. It could still blow down within that 10 years. So I don't understand the logic of why to leave it, and it could still.
Well, and maybe the house burns down in 10 years. Maybe they decide they don't like the addition and they knock it down and they start. I mean, a lot can happen from the homeowner side in 10 years too. I mean, the tree's been there 80 years. It hasn't blown down yet. I mean, you know, do you agree that it's probably 80 years, more or less, around there?
It's probably older than that, I'd say 80 to 100 years for sure.
I mean, it's just they understood the risk. They built the addition right next to the tree, and now they're coming a couple years later to take it down. It just the process, and I think you're right. I mean, obviously there was some miscommunication, if that's what we want to call it, but that's where I'm stuck.
Steve, you have a question. If taking down this larger tree poses a risk to any other trees, I mean, there's a potential for that, right? In your opinion, it might not be as much of a potential as the city arborist believes, but it would increase the potential for other trees to have more hazardous rating if this tree was taken down. What's your assessment on that?
Like I said, you might get a little bit more movement in the upper canopy of some of those trees. The remaining trees, there's gonna be a void there, you know, so they will be able to move more. But I think leaving the tree there, you know, because it's going to impact the building. If we get that tree out, the sooner you get that tree out, the trees adapt to the conditions that are around them. So the sooner you get that tree out, the sooner those trees can start adapting to the new conditions that they're not going to be exposed to.
Do you think that we need to remove that smaller tree next to it?
And next to it, I would
also.
I would, just because that tree has no limbs on it. So the live ground ratio on that tree, I don't really recall, it's very small. So once that tree is gone, when they're really close together, then it's gonna be exposed to the wind. That tree would help them block it from, and it's just gonna whip around like crazy up there.
Okay. Thank you.
Other questions?
Mr. Burt, real quick, just to confirm what I think you told us a little while ago, you really haven't looked at the root structure underneath the addition.
No,
Is
sir.
that correct?
No, sir. I see roots, I see buttress roots heading that way, but I haven't excavated to see where they go.
But I think we were presented with several photographs of what looked like damage to walls and parts of the structure. And if the stem of the tree didn't hit the structure, then at least it seemed to me like the roots were a likely cause. I mean, I'm kind of struggling. I wish we had some more detail on whether the roots actually were causing problems or not. And I realize you didn't look at it, so I'm not asking you for that.
It seems highly likely. I mean, it's very close. The roots, I mean, they're feet from each other, so it's highly likely that the roots are causing it, but I can't say for sure.
Thank you.
Would you have made that same statement 5 years ago?
Which one?
The statement about the roots causing the damage to the structure of the building?
Would it in the future cause damage? Yeah.
Would it in general cause damage? Would a structural system like that be impacted by the root system?
Absolutely. Anything on the ground will be, because the roots are they're gonna go every which way, and eventually, I mean, they're gonna start expanding, and they're gonna start displacing whatever's there. That's a pier block, and, you know, in this case.
In working with the city of Cannon Beach, you said you've been down in Guatemala. Looking at this, one of the questions that I think we have is there a gap in the system that the city has so that that structure could be put in place like this hasn't? when you have a root system that is gonna do it, that's, what's your experience in working with this city, other jurisdictions relative to the process between the arborists? And, well, specifically, again, between the arborists and the people that you've been dealing with over the past.
Again, it's just. I can't say exactly what, but it seems like there's no communication. You know, because if an arborist says, you know, if you need this amount of root structure for a tree to survive, and then yet they don't have that on the lot to make it physically fit, but the city still says save this tree. So then they come up with these crazy small tree protection zones that aren't gonna work in any world. So, I mean, I'm not behind the scenes, just I'm on the outside, so it just seems like maybe listening to arborists a little more before you try to fit the house, you know.
That's not a city issue, that's an owner issue, right? Because it's the owner.
I don't know how it works with the.
Yeah, I mean, because that is, what we get is a set of plans from the applicant that sets what they suggest based on their personal arborist as a protection zone, and so we're kind of stuck.
So can you just deny it then, right? It should seem like it
Maybe
should.
that's our obligation, maybe we need to know not to say that's not acceptable.
Yeah.
I'm trying to answer, because this is a discussion or a question.
I was actually just asking his
Yeah.
point of view, because I
Because
said,
we could get deep into.
we were, yeah, I wasn't asking,
But I would like to answer that question, but
I was asking a question for the gentleman who's here right now.
Other questions? Thank you for sharing. Are there other presentations by the applicant?
So I'd like to make a couple comments if I can.
Sure, absolutely.
So some things that came up was the discussion about what had happened on the site previously. And so in the package, you'll find this. We've had 3 trees at our house so far, and all 3 of them were city trees. And as a result of that, 9 other trees had to be removed. So there's been significant removal. The city removed all these trees. And Joe Birch was on the team that removed it. And so he's very familiar with the site. I'd say you should really listen to his thoughts because he knows that site better than we do. And so there's a couple things, other things that were talked about is the direction, like somehow we chose to go in the wrong direction. And you have to understand our property. Our property, we built as close to the street as we can to preserve that set of trees. And we're only utilizing about 25% of our road, which code says, I believe, 50%. But what is happening is you've heard the city arborist talk about these 3 trees that can't come down because the whole neighborhood would be in trouble. Well, those 3 trees are what is hemming us from being able to use the rest of our property. We put that addition in that space because that's the only place where we could put it without taking down existing structure or asking the city if we can build in the middle of one of their streets. It's just, that's the only direction. So for you and city arborists to say, gosh, you guys have to keep those 3 trees. You're limiting us to 25% of our property, which isn't what the code says, and it isn't what the city should be doing. We do have the right to use that property, and we have a modest house on it. It is nothing like the houses that are around us. We're right around 1,000 square feet on 2 levels. And our footprint is extremely small. And so the restrictions, it's not as if we intentionally caused this problem. It's not something that we did exactly what the city told us to do. We did everything. Got the arborists in, did all the separation, let the trees stay there, tried to live with them. And then now they're just too scary. They keep us awake at night. And I know there's members that think we should build a basement, which is gonna even cause more trouble with the trees or move because we're afraid to live in the forest, which is not the case. We have done everything we could to respect the forest and the trees that are with us. we have been thinning the canopy. So that's why there was evidence said that, well, yeah, it looks like the canopy's been thinned. So we do that on all of our curves to keep the neighborhood safe. So it's not as if we have disregard for trying to preserve our trees. It's just, we are hemmed in there and we want to be able to use the property and we want to be able to use it without being afraid. And so, based on that, we appreciate you listening to our arborist. Thank you for asking the city arborist questions. And we think when you look at all the information, it's clear that these trees meet the city standard of a foreseeable hazardous tree that can cause harm, property damage, and injury, and should be removed. So please comply with the code and let us take these trees down. Thank you.
Are you, last month of the meeting, I think you mentioned that there was an error in the design of some sort, or in the building.
Yes, we got a call when the house was, the room was being built. We got a call from the builder and said, we can't put the 12-inch eaves on there because they run right into this tree. And so that was a surprise to us. It wasn't as if we went ahead and tried to create a problem. We thought that the house was going to be able to complete it and there would be a safe amount of distance between that wall and the trees. Because we had the city arborist, we had everybody, the city approved it, the designs were approved. And so the answer is yes, there was some sort of problem with the eaves. And our solution to that was to go ahead and complete the project without the eaves.
I saw that photograph. Follow-up question to that was, so, when the footprint was marked out, the engineering diagram was done, then the addition came closer to the trees than you expected, is that correct? Otherwise, you would have been able to add the eaves on. So was it built to the engineering specs, or was there some kind of alteration in the building process that moved that building, that addition closer to those trees?
The building, the plans that I saw initially didn't have those trees there because the original plan was to remove the trees. And my understanding was the city arborist wanted to try to save the trees. And so we went ahead with the different footing to prevent that from happening. I think it was pretty much a surprise to everybody when the builder got up there and tried to put the roof on, because it's not obvious. And when you're looking at a tree trunk at the base, and then you up 15 feet trying to put on roof trusses, that something wasn't right.
And that's the city arborist's fault, not your architect?
I don't know whose fault it is, and I don't think the code really suggests that it's important to decide who's at fault when determining whether a hazardous tree needs to come down.
When you design into the hazardous tree.
I didn't do any designing into a hazardous tree. And as far as I know, the city didn't approve any design that had the structure going into a hazardous tree. And whether it's important to figure out who made the mistake or why it turned out that way, I don't see that in the tree code.
So you mentioned that 3 trees fell during the storm.
3 different trees have hit our time. We've lived there for 30 years. And so over the time, we've had 3 different events where 3 trees have hit our house.
And as a result of having to remove those 3 trees, 9 others had to come out, is that correct?
So the 3 trees that fell on our house over time were all from the city. So we asked the city if they would come to look at their other trees. And they did. And so they had their arborist, the city arborist at that time was a different gentleman. His name is in the article, I believe. And he came out and did the assessment and said, 9 of these trees are not safe. And so the city removed 9 additional trees. And that's what's there.
Was that a result then of losing those 3 trees that made the others unstable?
No, but so I'd be talking about things that I don't know specifically. The city has reports on what they did and why, but my understanding is that the trees that are on our lot have been damaged because when they put the road in and when the neighbors put the house in, they pushed all the dirt onto our property and it has affected the way those trees have grown. That's my understanding, but I don't have a report that says that.
Oh, just curious, because there has been some other comments here that removing two of them might put some of the others in danger. So I was wondering if removing 3 but 9 in danger and removing these 2 might also put some others in the canopy in danger of having to get removed as well. The domino effect that was mentioned.
I'm not an expert on that. I just know I want to be able to stick with it. Okay.
Any other question? And you can help me understand. In the file, in the city report, it says the addition was constructed in 2022. Or is that correct? Or was it constructed in 2020?
So I believe 2020 to 2022 is the time frame that all of this happened, because I remember there's some bit of COVID part that's into it, and so I believe the original, so the first hazard report that was done by Arbor Care that said the tree should come down, I believe does say 2022, and or speaking in 2020, and I believe the project was completed in sometime in 2022. So I think that 2-year, it can take a long time to
Yeah,
get stuff built here.
It just confused me, thank you.
But I believe that's the correct time frame from the beginning of it to when we moved in and saw what had happened. And that was a surprise to us. When we came here, up until we saw the house framed in there, it was like, wow, that's not what we expected. Everybody said we would have a good, safe space, and it doesn't look safe to me.
Yeah, you know, the thing is, it's not your arborist job to tell you that, or the city arborist job, and that's why people are struggling there, it's your contractors, and yeah, well, yeah, there's a point there. You know, we're probably gonna have to find a solution for you.
You wanna blame somebody?
No, it's just that you have to blame people, and I would just like to stay away from blaming people at all, if you're open to that.
I'm not trying to blame anyone.
I'm
I just
not,
want
some of the language,
unsafe trees. Okay, some of the language I've used
I was blaming people, so.
as I'm blaming.
Let's just, we appreciate the conversation back and forth. The purpose.
I appreciate it too.
Yes, we really are trying to dig in.
I can do better.
That's Other questions for Mr. Fidel? Okay. Thanks. Appreciate your time. Any other presentations by anyone on your team or as, proponents? Okay. Are there any presentations by Oakland? Staff responsible, too very well. Okay. We always offer you the final opportunity to say anything before we close the record. After we close the record, there's no further opportunity to discuss anything that you hear us discuss. We're good, thank you, you're good, all right. Then we will close the record and move to our deliberation. Is everybody okay with closing the record at this time and move to our deliberation? Okay, then we'll close the record and move to our deliberation. We'd like to start.
I'm trying to answer that question because it might give us some guidance going forward. Okay.
When you say that question, what
The question was, you know, what happened and, I don't know, you were attempting to answer it, about what was it about the process that broke down, you know? The reality is there's a lot about the process that broke down. It didn't have to involve anyone's fault. It's just the way our code's written. So we have learned, this isn't the first time this has happened. We learned that we need to get the arborist, the city arborist and the applicant's arborist together with the contractors up front. That's in the new code that's written.
How does that apply to what?
I wanna get that, cause I think what would happen is we have a new code, we would have a solution for everybody.
And I think the importance, I think what you're talking about is something I know you spent a lot of time on, but it does not apply.
The question came up here, so I'm trying to answer the question.
I know.
Everything that we have put into that code would have ended in a different result here, and none of us would be talking.
We're right, but we are where we are.
Mr. Chair, excuse me, Mr. Chair, could I just interject here and say, I think it'd be most helpful for the planning commission deliberations to focus on the criteria for tree removal first. And in your deliberations, just to kind of bring it back to what this appeal is really about, which is does the application satisfy the criteria? Thanks for letting me interject.
I understand what Mr. Friedel is doing. It is a difficult problem, and I don't want to minimize it in any way. I would like to reinforce some of the concerns we have when they come to us this way, and that, you know, there could have been a solution earlier, could have been not worth a lot of money, but there could have been, but we need to, and I know one person, among all of us, I guess, we're all very much tree oriented in the city. But when I look at that house, I'm going, holy cow, I don't care how it got there, something needs to be done, right? So leaving him without a solution here is not the right.
I think that's pretty good.
Okay, so with that, I would say, thinking about foreseeable danger, it seems like everyone agrees there are 10 to 15 years before there's an actual contact and danger. We had testimony today that the trunk itself is moving by maybe an inch in high winds. So to me, foreseeable danger in the code should not be interpreted to mean 10 years from now. We would be talking in the next year or two. We're not there yet, as far as I'm concerned. We aren't by the code.
I'm going to accept that, and I think there are other things, I'm shortcoming this tree, if Mr. Friedel would consider them, and that would get him ready to be able to cut that tree with minimum of damage to the rest of them, and that may be something he should consider. I don't know what the right answer is, but when I don't know if it's 10 years. I don't know if it's, this winter's the worst storm. I don't know what it's gonna be, but they have identified a risk. We're aware of it now. If it happens in 10 years, great. If it happens in one, we look pretty stupid.
No, I do not buy that at all.
I do.
To say that that's on us. Any tree in the city could happen to fall down tomorrow or the next day in a big storm. So for us to say it's our responsibility to therefore be liable because we made a determination, I absolutely disagree. We can listen to the experts. We had 2 experts agree today that the contact and therefore the danger point is probably 10 to 15 years away. So I would not want us to put out there any statement that we somehow are responsible for something that happens. If we have experts who say this is the general timeline, we can never know for certain. You heard them state any tree is basically a hazard tree.
It is, but you have
You can't.
this is a unique situation with a tree that's 8 inches from a house, 8 inches.
And it's not touching, it doesn't even in a highway.
But
There's 8 inches in my house, and a tree that's 100 feet tall, that's 20. I think that becomes a question, so we could make a danger argument, you could take the danger argument to the other trees that remain, that we have the city driver saying we're compromised.
Yeah, I don't disagree that you can call every tree in the city a foreseeable.
But forget about the city, let's just talk about the law.
Yeah.
We have the city job saying you're compromising the rest of the trees on our, we now say we cut them off. But that's the sort of logic you begin to walk down, if you say, with a 100-foot tree.
Yeah.
This is a danger to the house, it was a danger to the house, it was a danger to the house before the house was built. It was a danger to the addition before the addition was built, and the other trees remain added to the entire structure just by the nature of the house.
Yeah.
So, I'm not saying I disagree with the logic, it's a tricky spot, but there's certain pieces that I can't sign off on based on just. I don't know.
About the process that makes you feel uneasy about giving this.
Yeah, I think it creates a precedent that every person will come in here and say, well, in 10 to 15 years, this tree's gonna be a problem for me, so I want it down now. So in terms of how we interpret the code, we need to be consistent. And in the past,
or 20 or 30 or 40 years, this tree's going to grow enough to contact my house somehow. And someday it's going to fall down. So therefore, I need to cut it today. I mean, I just, I don't see it as being foreseeable 10 to 15 years. I mean, I agree with Mickey that, you know, closer to 1 or 2 years, 3 years. I mean, I don't know. Is there, Melissa, is there some case law or some standard that, you know, what constitutes a foreseeable risk here that you know of?
This is the city's, thank you for asking, Commissioner. This is the city's code. And so really it's up to the city to interpret those terms. Typically, the city looks to the dictionary definition of foreseeable and the dictionary definition of danger, which are used together here. So I think something could be, for example, foreseeable, but it might not pose a danger because it's foreseeable in too long of a time, or it could pose a danger if it's, reasonably foreseeable in a very short time. So I wish there was some guidance for you, but I think you're kind of talking about what do these words really mean, in the dictionary.
Yeah, I just wasn't sure if you know of some Oregon case that, has gone on through appeal and has set some precedent. Maybe this will be it. We'll see.
Falls around trees in Oregon.
So can I suggest a different question? So we were presented some evidence that there is actually physical damage occurring to the addition. Now, and we supposed that it was due to the trees, but we really didn't know. If I remember right, that was one of our conversations last time we got together about, was there a way to assess? Was it the roots causing damage to the piers? Why are there cracks in the walls? All those kind of questions. And we don't have that data tonight. But that's actual damage. That's not the likelihood of falling. That's actually damaging the structure. And at what point do we have to take that into account?
Les, to me, I would want to know very clearly that it was definitely a tree, because I can tell you from looking at my own house, there are cracks in the walls, there's cracks in the foundation, and it's not due to trees. It's settling of the ground, etc. So I would really, really be wary about assuming that it was the tree without some very, very clear evidence myself.
If you knew for sure the tree, would you feel differently about the discussion?
I probably would if it was 100% root right there in contact. Okay, we have damage. But I think my next question would be, is that damage going to change with time? So in other words, is the root growing that much? What we heard from the experts is that it's not likely the roots are growing much right now. That they probably put out their major root structure and that their earth is not changing that quickly at this time. So then I would say the damage is done. And in fact, you may, in removing the tree and degrading the root system, eventually cause more damage.
Well, I can't argue that. And I don't have that answer, why the damage occurred. But it seems to me like if I knew that, it would help me understand what the right thing to decide was.
Well, we don't know that, and it's not our job to tee it up for them 15 times and come back and bring us more evidence. I mean, we did talk about it, Les, you're right, and I didn't see any new evidence tonight.
No, it wasn't presented. I kind of expected it, but when I went back and read the minutes, I realized that right at the end of discussion, we decided to just bring in the arborist and ask questions. Anyway.
Yeah, I think it's something the applicants could come back with. We could, if we did end up denying, for instance, they can always reapply if they obtain new evidence.
Well, I think really, Mickey, what I was mulling over was not even so much that. It's like, if we did have evidence that it was the roots of one of those trees that was doing it, should we make a decision? I mean, there's nothing in our code that specifically says damage to a structure qualifies as imminent danger.
That's true.
I mean, how would we rationalize that?
And I guess what the question would be is it causing a foreseeable danger in terms of continued damage or not? If it's not changing, maybe it's not foreseeable.
I mean, this is all whatever. Right now. Why don't we,
Well, I think that, as Mickey said, we can't really predict any force majeure, anything for any of those trees around there. My concern is that if we take these two and in fact the canopy, then all of a sudden we've created another issue that may result in other trees coming down, and they're close enough to the structure that it sounds like that they would be a hazard also. So, where do we kind of end on this thing? What I would like to see is, some canopy reduction, in the interim and some planting so that, these trees, when they do apparently inevitably come down, that, there's still some structure for that canopy and the other trees in the grove. So that the other ones don't have to come down and they wouldn't be as big of a potential risk, as they would if these two foundational trees, come down. I think that would be a prudent method.
would be.
Okay, well, I think that, we've had a very good conversation here. If there's someone who'd like to put forward a motion.
I think the sentiment was very clear, so I will, I know that we,
Is there a second? I'll second that. Is there any further discussion? That's what we call one, please.
Excuse me, can I, before you do the roll, can I just suggest that, it'd be helpful for the planning commission to have the motion set forth the basis for denial, even if it simply refers to the criteria. Because this is an appeal of an administrative decision that denied the application on a specific basis. So if the planning commission agrees with that administrative decision, it would be helpful to know that.
Yeah. We say the last part one more time, just the last two sentences, which we said it.
Yeah, so this is an appeal of the administrative decision that was issued by the planning department, and it would be very helpful for the decision going forward to know if the planning commission, if the motion to deny the appeal is for the same basis that the application was denied administratively. Or if you're going to adopt new findings or additional findings. There's been a lot of evidence that came before the planning commission in 2 public hearings that wasn't before the planning department when it made the administrative decision. Is that making sense? I'm not a fan of the Zoom appearances. I just have to say I don't like this. So. And Robert and Steve, feel free to jump in here if I've inaccurately characterized something.
No, I think that's just add some additional evidence or support justification for the denials what we're at.
Robert, you've heard the discussion. We've had many different points that we've considered as a part of getting to this point in the conversation. Will you read the most pertinent part of the findings that you have in your staff report to us, please, and we can discuss them with ourselves if we want to, how we want to incorporate that. If we want to incorporate that.
What was that? I'm having trouble hearing.
Can you hear me now?
Sort of.
Okay. You may have to rather too. So the question is, can you please read what you believe to be the most pertinent sections of your findings in the staff report for us to consider what pieces all pieces, if any pieces we want to incorporate into any motion that we are going to vote on.
Let me see if I can find that.
Sure, we can be patient.
I think I was looking at this earlier. I think in the April 22nd packet, I think around PDF pages starting at 85, on the April 22nd packet, that of PDF 85, that contains the planning administrative decision, and then that relies on the city arborist decision recommendation, I should say, which is at page 87.
Are you not looking at that now?
That's effectively how the review took place, is it was implementing the recommendation of the city arborist.
Well, do you have that in front of you, Robert? Or Missy, is it in front of you?
I have it in front of me. That's
Will
right.
you read it, please?
Well, it's kind of long. So the basis for the city arborist conclusion, city arborist conclusion is that kind of exactly what he said tonight. This is okay. So I'm going to look at 85. This is PDF page 85, and it says, after reviewing this is the planning department decision. After reviewing this application, based on the recommendation of the city arborist, this application is denied. The application materials indicate that the purpose is to prevent future structural damage resulting from trunk and root growth. During the application review, the city arborist did not find that current conditions are posing a hazard to the residents. Additionally, the arborist found that the removal of the 2 trees may adversely affect other trees in the immediate vicinity. Based on this assessment, the city finds that the application does not meet the criteria of CBMC 17-114040. That is the pretty much the entirety of the decision.
Okay.
So I think our conversation tonight has largely affirmed that, but also went a little bit further, looked into the criteria of foreseeable danger, and also considered that. So it wasn't just current danger, but we also talked about foreseeable danger tonight, which may or may not have been fully enunciated in the earlier decision, the administrative decision.
So one thing somebody could do is either make a new motion or amend the current motion to articulate that the planning commission upholds the administrative decision because the planning commission finds that there is no foreseeable danger to public safety or property damage to an existing structure. And this is, or that the hazard or danger could be reasonably alleviated by pruning is a potential other basis. And I'm not telling you what to decide, but this is just, I think we talked at the last hearing, this is a unique situation because you're acting as an appellate body.
Well, you know, the other thing I heard in there was the piece of the removal of the tree would affect the other trees, and that's pretty significant.
It is.
Okay. You made a motion. Are you willing to withdraw or?
I mean, let me explore the foreseeability piece again. How do you propose we address that?
So we would affirm on the same basis as the administrative decision was made, which was that their current conditions were not posing a hazard and that removal of those trees could pose hazard for other trees in the road. And then in addition, we found that there is no foreseeable danger to keeping the tree in place.
Do we want to, do we even need to go with foreseeable if current is the standard? I mean, why not just affirm that?
I think that the standard is foreseeable in the code.
You may want it real quick, you can have it here, want to see it, or should I read it?
Yeah.
So this is permission criteria. Okay, so we're at 17.114.040, and it says removal of tree which poses a safety hazard. The applicant must demonstrate that the condition or location of the tree presents either a foreseeable danger to the public safety or a foreseeable danger of property damage to an existing structure. And secondly, it says such hazard or danger cannot reasonably be alleviated by pruning or treatment of the tree. So you're taking a look at section 17.114.040, which is permit issuance criteria. And it's A1 and 2 that talks about foreseeable danger and.
So I think, Aaron was right, there's no point in it up beyond that, based on assessment of the city versus city funds. Or we find the application does not meet the criteria in this code, 17.144.040. And that's it.
I think Misty said that we should actually incorporate some of the words of the criteria rather than just citing your code section.
Okay, so. Send that.
Something that's eight for 1 and 2 state conservation.
Yeah.
That exists now, and an agreement between the two arbors, that we've got 10 years before the structure protected by Windsway.
You want me to try to proceed with this? I'll try. So I move that we deny the appeal. For the reasons set forth in the city's, administrative denial. During the application's review, during the committee's review, the commission's review, the city, we did not find the current conditions are posing a hazard to the residents. Additionally, we agree with the arborist staff finding that removal of the two trees may adversely affect other trees in the immediate vicinity. Based on this, the commission finds that application does not meet the requirement of Cannon Beach Municipal Code 17.144.040, and specifically subparagraph A, which reads, removal of a tree which poses a safety hazard, the applicant must demonstrate that the condition or location of the tree presents either foreseeable danger to public safety or foreseeable danger to property damage to an existing structure, and such hazard or danger cannot reasonably be alleviated by pruning or treatment of the tree. Furthermore, the planning commission finds that there are, the hazard can be addressed through pruning and other treatments.
Your longest motion.
There's a second. I'll second. Any further discussion? Do we want to go to that, maybe tentative, or? That's we call it open.
Commissioner Sinclair,
Yes.
Commissioner Moore,
Yes.
Commissioner Matute,
Yes.
Commissioner Bates,
Yes.
Commissioner Wade,
Yes.
Chair Newton.
Yes. The administrative appeal, is denied. We great, or go ahead.
Could I ask a question? This is a question for Steve and Robert. Will the planning commission adopt the findings in support of their decision that they just made at the next meeting?
The idea is to take the motion that was done, create the findings and provide them back to the chairman for his signature.
Okay, great.
But those findings are not being reviewed by the body. I'm just saying what we just did. Okay, we're moving on. B 2502 and CU 2504, Scott Robertson, Higher Ground General Contract.
Yes.
Sure. U 2504, Scott Robertson on behalf of Eric. Later for additional use of various permits for residential development along the B 2502. 504, Scott Robertson on Higher Ground General Contracting LLC on behalf of Eric. And General Whitaker for the construction of new sandal and the drawing and weapons out of the the subject property is located in the corner of 16th Street, tax lot 305, map 51019 AD, the residential medium zone. The application will be reviewed in the code section about 102, but the red zone, subject to 6, condition uses and against the criteria. But not non-zero variance. Does anyone object to the jurisdiction of the planning commission to get this matter at this time? Does any commission member
Want to hang on until it's passed?
Yeah, sure.
Alright. Does anyone object to jurisdiction of the planning commission to get this matter at this time? Does any commission member believe he or she has a conflict of interest for a personal bias?
I'm going to err on the better side of judgment, read a statement, and allow the city attorney to make any comments she wishes.
Go ahead.
To not only protect myself, but fellow commission members and protect the impartiality of the planning commission as a whole, I make the statement as my possible conflict of interest in regard to CU 25-4 and D 25-02. I cannot identify a specific reason other than the nature of my personal business as a designer has and will require me to do similar projects to this one in wetlands areas. However, I do not feel that this creates or implies bias in any way. My understanding of the Cannon Beach Code, especially section 17-102, only making a more valuable resource to the community. Making the statement possible conflict of interest, I feel that there is no reason for me not to be part of any discussion or the need to recuse myself from voting in regard to CU 25-02 and B 25-50.
Missy, did you hear all of that?
We didn't have personal contact. I have no personal contact. I have no skin in the game with this application anyway.
Thank you. Thank you, Chair. I did get most of it. I actually just appreciate Commissioner Orloff's, candor in this, and I think I will just ask the question whether you feel like that you can consider this application impartially and make a decision based on the facts and the evidence.
Without any question and doubt that I will base my decision on the basis of our code and what is written therefore.
Any questions on the part of fellow commissioners? Okay. Has any commission member had any ex parte contacts or made a site visit? And we have a staff report.
Robert, do you want to do that or would you like me?
How well am I coming through on the audio?
Okay, we can hear you fine.
Okay, I'll give it a shot. So this application is for the construction of a new single-family dwelling on a partially developed property that is within local wetland inventory site number 19. Existing development consists of an elevated steel frame and subterranean utility connections. The existing development was authorized by Oregon Department of State Lands Removal Fill Permit 41880-RF that was issued in June 2009. This application seeks to complete development of the property through the utilization of these existing on-site resources in order to minimize ground disturbing activities. Wetland delineation 2024-0284 shows two distinct wetland areas totaling approximately 840 square feet. The remainder of the site falls within the 50-foot buffer area for these wetlands. No tree removals will take place as there are no trees present on the property. Moving into the applicable criteria. For the wetland overlay zone requirements, just scrolling down here. The first staff comment is that due to the site's configuration, there are no opportunities for development outside of the delineated wetlands or their buffer area. However, through adaptive use of the existing 2,470 square foot pile-driven structural framework and utility connections, the applicant will be able to minimize the amount of ground disturbing activity required to complete development of the property. The majority of the home site falls within the buffer area, with small portions of the wraparound elevated deck being within the delineated wetlands themselves. The proposed dwelling will have a footprint of 1,220 square feet, which exceeds the 1,000 square foot maximum allowed. Additionally, the wraparound deck will measure 1,340 square feet, which exceeds the 400 square foot maximum for non-structural hardscape. Additionally, an off-street parking area is proposed on the southwestern corner of the property. As the proposed footprint and other hardscaped areas exceed the limitations imposed by 17-102-070B1, the applicant is requesting a variance to these standards. Continuing onward into the development standards. The primary mitigation measure taken by this proposal is avoidance of ground disturbing activities by utilizing an existing pile-driven frame to serve as a foundation for the dwelling and deck. Mitigation measures specified by the application include the placement of heavy-duty landscaping fabric along the western and southern portions of the existing frame that will be covered by 4 to 6 inches of bark chips to prevent ground disturbance to the wetlands from construction equipment access. Silt fencing will be placed along the remaining wetland boundaries to prevent inadvertent equipment access. A parking and staging area will be designated in the southwestern corner of the tax lot and will be topped with 3/4 minus gravel. If additional parking and staging is needed, it will be located on existing gravel areas on Hemlock to the west. A bark chip path will be created between Hemlock Street staging area and the staging area off of 6th Street. Bark chips, silt fencing will be removed following construction. Soil will be tilled to loosen any compaction, followed by seeding and with native coastal grass seed mix. Prior to construction, knotweed and blackberries will be removed by hand and or herbicide. And the list continues on. In Exhibit A5, the best management practices and restoration plan also includes a monitoring plan which identifies performance standards, including that seeded areas will have at least 80% cover after 1 year. Native trees and shrubs will achieve 100% survival after 1 year. Occurrences of Japanese knotweed and invasive species will be removed from the property for the duration of the monitoring period. The installation of permanent demarcation wetland bees boundaries will prevent inadvertent access in perpetuity, and monitoring letters will be sent to the city of Cannon Beach by December 31st for a 5-year period following submittal of the as-built letter. Moving into stormwater standards and stormwater design. The application narrative indicates that stormwater will be conveyed into the wetland buffer area. However, no methodology was provided. The site plan included in Exhibit A4 shows a storm drain connecting to a municipal catch basin on the southwest of the property. This basin is then connected to the city's larger stormwater management system. Moving into conditional uses. The staff comment is that the subject property is zoned residential medium density R2, and a single-family dwelling is a permitted use in that zone. The surrounding neighborhood is residential in nature, and the property was originally intended to be developed as a single-family dwelling. The proposed development is small in scale and will not generate a significant amount of traffic or demand on public infrastructure. Moving on into variances. The first staff comment is the Municipal Code 17-102-070B restricts maximum density coverage or maximum building coverage on a wetland lot of record to 1,000 square feet, with an additional 400 square feet allowance for non-structural improvements such as off-street parking areas, walkways, patios, etc. This application proposes to make use of an existing 2,470 square foot elevated pile-driven steel framework that will be used to support a dwelling with a footprint of 1,220 square feet and a wraparound deck of approximately 1,350 square feet. An additional grass and gravel off-street parking area will be provided on the southwestern corner of the property. The presence of the framework provides a limited opportunity to develop the site without further ground disturbance. Not being able to make use of the framework may result in its continued presence as an incomplete structure or an eventual need for its removal in order to accommodate a development that complies with the limitations of 17-102-070B. The prior construction of the pile supported foundation is not considered to be a violation of the municipal code or any type of self-induced hardship, which could qualify this from being considered as part of a variance request. And moving into the off-street parking and loading variance request, the applicant requests that the 2 required off-street parking spaces be located partially outside of the property's boundaries near the intersection of 6th and Hemlock. At present, this is an undeveloped portion of the public right-of-way that is covered in low-lying vegetation. It is also an area of wetland buffer between the 2 delineated wetland areas on the subject property. No structural improvements are proposed as part of this variance request, and the off-street parking area will consist of gravel as per the site plan. And that concludes the staff report.
Okay, thank you, Robert. Is there any additional correspondence that came in, that say having 2 o'clock?
I think we had sent to everyone letters this afternoon that did come in. I think there was some photos from neighbors to the north that were part of your packets. So that was the only correspondence, and we had provided that to you.
I was mistaken. I was sort of,
Yeah, neighbors. One is the first and kind of photos today.
I didn't know.
Yeah.
I looked at the picture.
Yeah, I just had. I think that's. One is the same. Yeah, the bottom is.
Okay.
Jared, can I ask a question of our staff?
Yes.
Just for clarification, we have a conditional use permit and then we have a variance. And the variance is for specifically the additional area and the off-street parking variance, correct?
Correct.
Okay. Now, are they to be considered together or separate?
This is all one application, so you could take actions on the conditional use permit and on the variances separately if you chose to do so.
All right. We'll move into public testimony. Pertinent criteria to be considered are noted in the staff report listed on the criteria sheet on the meeting page of the city's website. Testimony, arguments, and evidence must be directed towards the proposed criteria or other criteria in the comprehensive plan or municipal code if the person testifying believes compliance with the decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue precludes appeals based on the issue. Prior to the conclusion of the initial evidentiary hearing, Any participant may request an opportunity to present additional testimony, arguments, or evidence regarding the application. The planning commission shall grant such request by continuing the hearing or leaving the record for additional written testimony, arguments, or evidence. Persons who testify shall first receive recognition from the chair, state their full name and mailing address, and if appearing as a representative, has to be identified from neighbors represented. Is there presentation by the applicant?
Good evening. Thank you for hearing myself and my team tonight. I'm Scott Robertson. My address is 672 North Hemlock Street. And I'm a general contractor representing my clients, Eric and Joanne Witcher, who purchased this property that we're talking about here, 115 East 6th Street, March of 23. December of 23, they hired me to begin working on this project. And this is something that has been there for over 15 years now. Many of you probably have seen the steel structure there at that lot. And it just sort of has been languishing until they purchased that with the original plans, a set of Jay Raskin plans. I believe he was at one time mayor of Cannon Beach and a well-renowned architect. And so the client's idea was that they were going to purchase the property with the existing pilings and foundation and those plans, and that we would just be able to move forward with that. But since things have changed quite a bit in 15 years since that was put together, we have realized that we weren't going to be able to realize that initial vision. That house is going to be way too big for what is going on here in Cannon Beach now. So what we've done is I've been over the course of this last year, put together a team of experts. We have a new architect, a new set of plans. I'm a land use specialist, and we have a wetlands expert here with us tonight. So we have a bunch of great ideas that we'd like to share with you, and then if you have questions, we will take those as well. So now I'd like to introduce the land use specialist, Joseph Schaefer. Thank you.
Good evening. My name is Joseph Schaefer, and I'm a land use paralegal at Jordan Ravis. My address is 1211 Southwest Fifth Avenue, 27th floor in Portland. I just want to give a little context for what we're dealing with here tonight, and I'm going to turn this easel so I can see a little better myself while I speak to you. But essentially, we have two issues that we're trying to address with this application. The first issue is the wetland. And the second issue is our concerns from the neighboring property to the north about solar exposure. With us tonight, we have Gabby, our.
Mr. Schaefer, forgive me for interrupting. I want to make sure the commissioners on the line. Can you guys see what, I don't know how these cameras work honestly. Can you guys see what's being presented to us here, what Mr. Schaefer just moved slightly? That's fair, and that's for you guys. Can you?
No,
The
you
camera
can't.
keeps moving around.
Okay, so I think, Mr. Schaefer, when you're referencing a particular, well, you'll be speaking, so it should,
Yeah.
when he's speaking, does the image show?
Probably gonna focus on Cannon, not.
Or do you have the sheets handy? So if we read off the sheet number, do you have something you can look at to see what we're talking about?
Yeah,
I have the packet open.
Okay,
One, if you're
Most of
referencing
these-
something, maybe use the sheet number, so they.
Right.
Very good. Just want to make sure, please.
thank you. So I'm speaking about the planting plan right now, which is item 7, drawing 7. Just to speak in general terms, if that planting plan is a site plan not only of our site, but of our surrounding right of way. You'll see on that plan, especially the wetland in the northwest corner of our property continues off-site. So the site plan is expanded beyond the four corners of our property. We think that's necessary to, sort of illustrate the context of what's going on. And of course, Mother Nature doesn't the property. And then, yes, sheet 9 is also similar plan. Same plan? Okay, just different labels. Okay. I'm gonna talk about two things in the staff report. First, I'm gonna reread a sentence that Robert read a minute ago because it's a beautiful sentence and it's very accurate. I wish I had written it myself. The presence of the framework, the steel framework, provides a limited opportunity to develop the site without further ground disturbing activity. That is the whole crux of the wetland variance. The structure's there, the underground utilities are there. And we would like to utilize them without further ground disturbance. Now, as Scott mentioned, the code has changed. We're proposing a much smaller house. And Jacob can explain the design of how the shape of the house and the location of the house were derived. But the gist of it is, we start from the proposition that the code allows 100,000 square foot footprint. 1,000 square foot footprint and 2-story height. So the sort of the basis of the architect's program, if you will, was a 2,000 square foot house. So, yes, we could have a 2,000 square foot, box. Jacob has what we think is a better idea, both aesthetically and then also to minimize the shading for the property to the north.
Which is the brown, which way is north on you now?
North is straight up.
Oh, thank you.
So what we're talking about is, this is the neighbor's house. You can see it's skewed to the property lines. It's closest at this point, which is about 7 or 8 feet from the property line. And I'll let Jacob describe that in more detail for you. The second piece of the staff report and Robert's comment that I would like to address is the stormwater. So we approach this as wetland, okay, the house is essentially in the wetland buffer. We thought the city would like to have the water stay in the wetland. And we would find a way to distribute roof drains essentially right on site on the surface. In speaking with Trevor at Public Works, his preference was to connect to the existing storm drain. So the application narrative, which I wrote, said, well, just put it on the ground. Later on, I learned that Public Works says, put it in the skinny bin. The applicant team is fairly agnostic, whatever the city prefers on that, we'd be happy to do it. So, that's all I have, unless there's any particular questions.
The question, so it's all native, vegetation, I think. All native, you reference this.
Yeah, I'll let Gabby give you the details on the landscaping. I will say that we have a lot of non-native vegetation there now. And when Gabby and Jacob are done, Scott is gonna talk for a minute about the construction management plan. And so we have two kind of hazards. One is getting rid of the non-native vegetation, which Scott is handling. And then Gabby will tell you about the work. Thank you. Okay, thank you.
Hi, thank you for having me here tonight. My name is Gabby Bender, and I'm a wetland biologist with Ecological Land Services. We're located at 1157 3rd Avenue, Suite 228 in Longview, Washington. And similar to how the arborist presented in the last case, I wanted to start by asking our council members and the commissioner here tonight if you'd like me to start with an overview or if there's any particular questions you'd like to start off with. Perfect. My colleague Stephanie Simpson, who could not be here tonight, led the redelineation of the wetlands through the 2024 DSL review, which approved our boundaries of wetland A that you see here. I'm sorry, I'm a little height challenged. And wetland B, which you see extending into the 6th Street driveway. The remainder of the property, as confirmed by the staff report, is consistent of the 50-foot wetland buffer area. And the reason for our variance request is because of the confined space and the inability to go deconstruct in uplands as non-existent on the property outside of areas that were previously approved for fill when the pilings were installed. So for that reason, we wanted to maximize enhancement and restoration of these existing wetlands to the greatest extent possible, improve the habitat functions, the water quality, and hydrology functions of the units. Outside of construction management that Scott will talk about, just in a little bit here. Once the site is ready to be restored and have mitigation components installed, the first step will be tilling soils to remove any compacted areas and installing this coastal grassland seed mixture, which consists of native seeds, typical to Washington or Oregon coast, that will result in various different grass and forest species, which will grow in clumps, mounds, and spreading formations, which are applicable to a variety of local habitat and fauna that would utilize the area, particularly deer, which may browse on the grasses, birds, smaller mammals, squirrels, chipmunks, those types of things that you may commonly see in more residential urban areas. The seed mixture is also documented to improve biofiltration functions for any stormwater runoff that might not make it into the city's storm system as per the city's request, which is common for roof or decking that will be adjacent to the wetlands and other areas. And then I guess let's move on to the shrubs that were selected. Shrubs that were selected for planting on the site. The way they're shown on this figure, it should be noted, is not the exact placement that will sorry, I've done woodwork sometimes. It's not the exact placement that they'll be installed. The biologist or contractor on site will determine their best available location based on the on-site conditions at the time of the installation. Those will be documented in the as-built report, monitored for that 5-year period of time. And the 2 shrubs in particular are being proposed here. One is salmonberry and the other is Nuka rose. Both are very well known for their ability to create native volunteers, to spread over time, to create a dense thicket, which will improve both water quality functions and habitat functions, as well as provide a food source to the wetlands and buffer areas. 3 different trees were spec'd for the restoration plan and enhancement as well. The first being the logical pine, which is one of the most common tree species we see at the Washington and Oregon coast. It was specifically selected in this case because it is a fairly short tree in stature, so it will help prevent any light issues going on to neighboring property to the north. You see the lodgepole pines are proposed here, right outside of wetland A, and here right to the west of wetland B. So given their proximity to the home itself and where it may have proximity to the existing home to the north, that species will ensure we're not overly shading the northern property. Oregon crabapple, which was selected, is also a shorter growing tree in stature. It creates native volunteers similar to the shrubs that were selected, largely due to the seeds that are spread from the fruit it creates. And of course, it's very obvious in the nature of the tree that it contributes food that would benefit local habitat. In Sitka spruce, we have 3 trees that are proposed in the right of way, just to the south of wetland A. And the reason these trees are being proposed is because the wetland A contains a forested canopy, which predominantly consists of western red cedar and Sitka spruce. Cedars were not selected for this particular case, not only because some were recently planted in the wetland A area by the contractor. We got the last year correct time. But Sitka spruce are less susceptible to disease than cedar, and they have a faster growth rate and will contribute to a more complete growth formation. Outside of the species that were selected, the general words, not my strong suit. The general idea behind the shrub and tree planting plan is to create a dense woody stemmed environment which slows and filters hydrology, given the shallow groundwater table present almost everywhere in a coastal region. That will help promote infiltration and will promote less standing stagnant water in winter seasons. Given that, I do want to point out that there is no enhancement and restoration proposed on the northern side of the decking and the very far eastern side of the decking here. One reason is for accessibility. And this area right here does contain some small concentrations of Japanese knotweed. And Scott will talk about these methods that he's been using on site for controlling the Japanese knotweed, but we're outweighing the control of knotweed versus planting over it due to knotweed's nature, and it's more important that we shade out the plant without using pesticides or herbicides and cover the area with plastic to break up the rhizomes and root balls to prevent the species from continuing to grow. The applicant may choose to enhance these areas after the knotweed has been eradicated, but that places a higher ecological function. That being said, any questions about how that plan was developed or why certain species were selected?
I think I might have some questions about restoration versus mitigation.
Yes.
But could you tell me, I don't know if you're the right person to answer that, maybe it's someone else on the team. When I look at this, the disturbed area is at least 2470 square feet, but I'm not seeing mitigation in the same areas what's disturbed. So how is that being balanced out? Because code says 1:1.
So this area where the home is being proposed, the mitigation was covered in the previous DSL approval in the core permit through the purchase of in-lieu fee credits. These small areas where you see encroachment into the wetlands, we're not considering those in particular to be direct wetland impacts or buffer impacts because the home itself will be raised on the existing ceiling piling. The area will allow hydrological connectivity from wetland A to wetland B. It will also continue to provide functions for habitat coverage and general. I'm at a loss for the word I was thinking of, but locations for wildlife to rest and to breed, as well as to kind of store their Thank you guys, and I apologize. I'm making this now. I know we're saying,
I think we understand what you're trying to say.
yes, but the niche within the herbaceous layer will be located below the home. It allows various layering opportunities for small wildlife to hunt for food sources as well as maintaining the high resource itself.
When we passed this code, part of the conversation was the disturbed area would be the coverage. Any impervious coverage, and that includes both porch and home. So I think that the way that we've interpreted this code is a little differently than you're trying to characterize it. Which one of the team would we discuss previous mitigation versus current mitigation with?
Yeah, Gary's most familiar with the prior, permit.
So, under our code, it states that, mitigation is required. And it says that although there may be ratios that would apply for federal or state mitigation, so long as that mitigation is equal to or greater than the city minimum requirement. So they paid $4,818 in mitigation when this frame was put in. That certainly didn't equate to the same mitigation that our code requires. So my interpretation of the code is that in fact, you still need to do the city level mitigation here. You can't rely on that previous offsite payment you paid into a fund or the previous owners did. So could you explain to me how you would address my concern that this still requires city mitigation
Yes.
through this code?
Yeah. So my professional interpretation is that mitigating for this area that will be developed a second time would constitute double mitigation. The reason for that being that the JPA process that allowed that core and DSL approval required Cannon Beach city approval, which means that Cannon Beach, when they originally approved the prior home design from 2009, decided that that purchase of 0.06 acres in fee credits, which equates to $4,000 some odd dollars you mentioned, would be adequate to mitigate for the direct wetland impacts as well as the indirect shading impacts that would occur.
At the time, the buffer was 5 feet. The buffer is now 50 feet. So actually what was considered mitigation necessary under the previous code now applies.
And that's a little bit of a sticky situation, and I have identified a section of code that I wanted to bring up in case that question was asked. It is 17.102.020E, which states that portions of protected wetlands that are legally filled in this chapter shall change to wetland buffer area. And in my professional opinion, of course, I agree with your interpretation of the code. That's written very clearly. filling a wetland and then constituting it as buffer creates a process where you have to come back and then propose buffer mitigation after you propose wetland mitigation, which would in a sense be a double dip or a double mitigation.
I don't think that's what's happening here. So we are saying that the buffer is now 50 feet. So whatever was filled in the wetland is still in that wetland area or close to, but the new buffer would require larger mitigation than was required previously, whether or not there was fill involved.
We certainly understand that interpretation. ELS's professional interpretation is that filled areas constitute wetlands regardless of the way the code is written. So we can certainly come back and propose additional mitigation if that's what council wants to see to get full approval, but in the professional opinion of Ecological Land Services, that is not the most appropriate interpretation of filled areas.
Other questions? Yeah, the original ESL approval, for 44, I believe it was 43 square feet, that was for the frame itself and installation of the frame, correct?
It was 43.22 cubic yards of fill and the rest that was for the frame.
Now, that was done under ESL, was there any Army Corps of Engineer involved?
Yes, nationwide permit 2009-53. It was authorized under nationwide permit type number 29.
Now, what about current standards for DEQ? Do you do anything with 401?
To my knowledge, there are no current standards with DEQ. I'm here today on behalf of my colleague Stephanie Simpson, who has more experience working in Oregon projects. My simple base of knowledge from DEQ is their best base of science is where the 50-foot heading comes from. But other than that, I really need to follow up, unfortunately.
What about additional fill that you're proposing now?
Based on our interpretation, because of the way the home is being proposed, there would be no additional fill. I can let Jacob speak to the materials of the decking. It's certainly something you can reassess based on the opinion.
Okay, I'll take them off.
Any other questions?
Thank you. Evening. My name is Jacob Chavez and my address is 7873 Southeast Left Avenue, Portland, Oregon. And I am the designer for this home. My thought is that I would just begin by explaining to you kind of the overall approach for the design of this home. And also how that relates to the variances that we're asking for. Does that seem like an appropriate way to start? Yeah. Okay, so because of this lot is oriented, east-west here, 50 by 100 lot. Oriented east-west, it's kind of a wide lot. As you see there on the kind of lower left-hand side of the site plan, there's a lower entry stair platform, which is approximately 21 inches above grade. That in itself has one single piling right in the center of it. So because this steel frame is at 42 inches above grade, you have to have means to get up there, and so that was designed originally to be kind of at that midpoint. So the initial intent of this design was to utilize as much of that existing frame as we could. And that included that entry. So the design began with aligning the front door, the main entry with that stair platform. And what this led to is was a design that was kind of wider, I would say, and more kind of elongated, which felt more appropriate for this lot. So in addition, the home, in order to kind of keep the mass of the home down, because we were already at a disadvantage, because the home is up on this 42-inch high platform, essentially for the roof height. We're not asking for any kind of variance, but was
we essentially lost that 42 inches in height. So, the goal there was to kind of work with that, overall, elongated or wide nature of the lot. And to, take some of that square footage from, that would otherwise be a second story of a 2-story, 1,000 square foot, on each level home. So the intent here was to reduce the mass essentially, by taking 220 square feet approximately down to the main level. And so essentially resulted in this plan, which you see with the heavy red lines and over it. A little difficult to read there, but the intent there by showing those red lines was that was the previously approved design. It was a beautiful home design, but it's no longer allowed in the current code. And so, as you can see, the new home, massive of it is reduced. If I can maybe find the front elevation or that can also be found on that one there. So that can also be found on page 11 of the submitted packet. There goes the front elevation, which have a reduced mass and kind of a lower structure, which I believe is more in line, appropriate with the character of the neighborhood. And that's about all I really have. Does anybody have any questions? Yeah, how do you say that's 28 feet from the ground up to the highest point of the house down there? That's correct. Yep. To the ridge, yes. Which is roof height maximum for a home this area. What is the problem with the neighbor to the north? You keep bringing that up. Yeah, the neighbor to the north, he's concerned about, solar access. He's concerned about losing some light. And so that was part of our response here was to design this in a way that was, sensitive to that concern, without, overly compromising what the owner is trying to achieve with the design. So I'm confused, maybe, Steve, you and Albert, don't they need a setback reduction for the
No, they don't. They're meeting all the setbacks. So this home is meeting all the required setbacks. And in fact, I think the home itself is 8 feet from that, on the property line, and it needs to be 5. So there is some space there. I think when you take a look at the site plans, you can see the front of the diagonal house, and you can see how that reflects to the proposed porch of the new home. And you can see that there's space that's there, and based on that elevation and how the brook runs, I believe it's was run east-west. That's why they've looked at certain things, I believe, to try to attempt to alleviate any type of concerns with solar access to the property to the north.
So that's not when you regard the rear yard then? I take it.
That, yeah, right. There's
Do you agree, rear yard is over here?
we have 2 front yards. And then, and Robert, you can correct me if I'm wrong, 2 fronts and 2 sides.
Correct. This is a corner lot, so the street facing yards are 15 feet and the other yards would be 5. And this proposed floor plan does comply with those setbacks.
Alright. And if I could say, we actually have increased the setback
by an additional 5 feet. In fact, so you can see on the site plan that I just put up there that the setback to that line in the middle of the house is actually 10 feet.
Yeah, okay,
Yeah.
thank you. I have quite a few questions. I know.
I've got a brief one. You addressed dark sky lighting. It looks like in the elevations, there wasn't any dark sky lighting. And the lights that were there were open.
Right. Are you referring to the rendering?
Yes.
The sheet, yeah. So, the rendering is just a conceptual AI rendering. It, the actual, lighting location and selections, are on the landscape plan. And we had also, located those exterior lights. They would all be, I can send them to you.
So maybe fully shielded?
Yeah. Okay.
It looks like sheet number 6, that kind of put it landscape plan.
Right.
You don't have any cut sheets on the lighting?
I'm sorry?
You don't have any cut sheets on the lighting?
No, not at this time, but, it would all be, similar to the style of the look on page 7 there, showing you pure mounted lanterns, stairway lighting, that faces down, this type of lights. We anticipated that, should, this move forward to the point that we would move the next, whatever one of the next steps would be to select for all the lighting, get those approved.
I do have a couple questions, let's start on the setbacks. Yours, corner lot, 15, 15, 5, and 5. I said on your south elevation, you project your deck into that 15-foot setback, which is over 30 inches, which is a non-compliant.
Right.
That's the first one.
The arch there?
Yes.
Right.
Your second one is on the south property line for the entry, where our code clearly states 1760 0.080 that patio decks no more than 30 inches are allowed to project into required yards, but may not be closer than 2 feet to a property line.
You're referring to the landing?
Your south entry, yes.
Yeah, the front, yeah.
Your steps are non-compliant.
The steps themselves, I think you're referring to the landing itself can't be within 2 feet.
Correct, yeah, the existing frame is 2 foot 2 away,
Right.
but you also have, are your masonry fronts 2 foot high?
Those are 30 inches.
30.
Yeah.
Or fence about 2 foot with steps.
Yeah. Yeah,
But the bow in the front is definitely not.
right, yeah, the bow, that is something that, you have requested, but I understand that, that's something that would require additional variance and, that we don't deal with.
Yeah, that would be
Yeah.
variance for setback reaction. I like very constant, but it's a very good thing. In regards to the frame, the structural frame that you're working with that's existing, could that have been modified?
We looked at that, and, the thing is that the pilings, there are 3 rows of pilings, and they're 15 feet apart. So the problem is, we looked at the possibility of removing, say, a row of those pilings. Well, the trouble is that only leaves us with 15 feet. So in order to, which is basically the width of like a skinny house, right? So, the only thing that could be done with working with those, 2 rows of existing pilings would be a skin roll. It would be 15 foot wide. I think it was like 60 feet long.
Oh, it doesn't mean that you couldn't replace pilings.
Exactly, yes, correct.
It could have been modified.
This is true, but yeah, the intent here was to minimize the impact on the wetlands.
Sure. The reason why I'm asking is that you're asking for a footprint of 4,000 square feet, roughly at 300. It's 1,300 is your footprint of the structure.
1220.
1,220, so you're asking for 200. I understand that 1,000 square feet is very restricted. But you're also asking for 3 times the amount of non-structure.
Right.
You're 400
Right.
to almost 1,300 square feet.
Right.
Where I'm going with this is have this frame, you're, tying yourself to the frame inside. So, but because you're not looking to modify it, and you're now asking for a change in the variance in size, but also a variance in parking. I can see in the front that your frame is restricting your parking. As stated, we're required to have two sites on the property. So had the frame been modified, your parking would have been within your property line.
Right.
The house could have been smaller, it would have reduced the amount of deck, which would have reduced the impact on over 400 allowable. So have you explored any designs that would have modified that?
Yes, so I'll address both of those separately. So the first one, working with the remainder of the existing frame and making that all deck. I think that the idea there, the intent was that again, we're minimizing the impact on the wetlands, we're minimizing the amount of, demo and work that we're doing there, be sensitive to that. And so, by working with that existing frame, then, naturally the rest of it would need to be covered in some way. And so, the most obvious thing would be to make that a deck and a walkway around. And then regarding parking, that portion of the site is kind of the only, uplands of the whole site. And so, in order to make that parking on site, we'd actually have to bring in some fill and, cut the pilings down, but then also bring some fill, compact it, and make that parking. So again, to be, low impact on the wetlands and sensitive to that, that's essentially how we arrived at this design.
Joseph Schaefer speaking. I would add that, we rarely try to avoid dealing with filings, okay? And to err on the side of not disturbing the wetland. If the commission would rather see, less deck and do what you need to do to take some filings out and add some new ones in, we're listening for sure. We just decided to err on the side of not messing with the structure that was already in.
Can you talk to the conflicting ideas of protecting the wetland from what has been done to what will be done, or will be impacted to the wetland from what has already been done, to the impact of the wetland by the addition that you proposed?
Yeah, Jacob was talking, Gabby and I did the math, and she can explain sort of the square footage of the mitigation that we're doing now, Gabby's proposal.
Yes, so with what we're currently proposing, we have 1,380 square feet of seating area, as well as 705 square feet of planting based on the on-center calculation, which gives us a total of 2,085 square feet of mitigation. So, Scott, would you be able to confirm the total amount of square footage of the home here?
The lot is 5,000.
And that footprint, our steel structure, is right under 2,500.
So that leaves us with a deficit of just over 400 square feet of mitigation that would be required the way the code is written.
Yeah, and some of that could be made up, earlier Gabby was saying how she doesn't show planting along the north and east boundary because it's gonna take a while for our Scott to make the knotweed go away, because we're not using chemicals. So there's additional area for that, we haven't tried to calculate it,
Correct.
but there's a significant extra area up there on those two sides.
And we can calculate how that area would add into mitigation is to meet that 1-to-1 ratio that's required by code.
I guess the point is we're awfully close to having 2,400 feet to work with. In addition, I think we're, showing some plantings that are happy to plant outside the four corners of the lot. The rights of way on both sides are, I wouldn't say undeveloped, but they're certainly of the, low impact skinny street, variety.
Boarding in progress.
I'm sorry, was that a question?
No, sorry about that.
Oh, no, fine.
One additional thing.
Clay, will you, I'm being kicked out of my office and I just logged in from my phone. Will you promote me from my phone? So I'm going to hang up from
Yeah.
my.
Rusty's on
One additional measure I would ask that we could utilize for mitigation is there are some existing mature plants underneath these pilings that can be relocated to the north proximity or the east proximity of the property, mainly consisting of skunk cabbage and buckrush. They're fairly mature, fairly large, could be easily dug up and would survive even with some minor damage to their root structure. And those would contribute to the volunteers in the bottom areas as well. The resources are available despite being less than 1-to-1 on the figures.
Are there any other questions?
I have a question, or maybe it's two, if I may. It seems like that the plan from the beginning was to preserve the steel structure for the, for the purpose of reducing impact to the soil. But how much effort was really put into what would it really take to remove that structure? And how much impact would we really see? Because without that in there, then obviously you could bring in a house plan that met all of the requirements of a wetland buffer lot. I intuitively understand we're not going to disturb as much dirt, but did you really look into what it would take just to get rid of it?
Well, yes. Joseph Schaefer here, I'll speak toward the microphone instead of looking at you on the screen. Yes, we did look at that, because then you're looking at two impacts, okay, so in terms of actually getting the steel that's there out, okay? You're talking about getting a crew in there with torches presumably, and then cranes to lift it out. For the pilings themselves, we won't try to dig them out, so to speak, like you might pull a fence post. We would excavate around each piling, and then the person could reach into the excavation with a torch. I'm not sure how big the excavation would need to be, but room enough for, a worker's arms and the torch to get in there and cut them. And then we're in a situation where the steel structure is gone, okay? Then we have sort of a new impact of a compliant house, whether it was an at-grade house, which we think would have a larger wetland impact, and Gabby can articulate that. Or we could, propose another house on islands there, a different arrangement.
Well,
Can you elaborate? Let's go ahead, give us a brief question on it.
well, and that's kind of the question just to me is, I feel like we're being asked for quite a bit in terms of variances, that all hinge on saving a 15-year-old structure that really wasn't ideal. And I'd just like to have some assurance that we're really getting the benefit that's being offered by not disturbing the soil or, you know, any more than we have to. I just really can't quite get there. I mean, I have a cutting torch. I can cut off steel beams. It doesn't seem like it's that hard to me, but maybe I'm mistaken.
Right.
Go ahead.
Hi. I'm Scott Robertson, I can speak to that. At the beginning of this project, I actually had, a structural engineer there, and a steel expert, and those people will be brought back in at the appropriate time. Should we, move forward with this, but so, the post pilings are massive, and there's some 50 feet down each of those. And so I'm not certain if somebody would want to leave the most of that underground, and just leave that in place. We're gonna cut it off, we're gonna disturb that whole area. And then I would have to just turn to Gabby and ask her, what do you think we would be left with at that point? How are we gonna fix that and bring, I don't know, are we gonna try to pull those out? Another thing I'd like to mention with regard to those 50-foot pilings, it's been determined that is where the solid ground is at that depth. So if we were to say pull back the north side of that, we would have these beams now are cantilevered out with no support. We'd have to sink new pilings in there. So these are things that we considered, but we also just came back to, and after dealing with the steel expert and the structural engineer, you know, examining this thing that's been sitting out exposed for about 15 years, we determined that it is retained its integrity, and with a little bit of reconditioning, it's be suitable to build on. So,
Are you adding to the steel structure in any way?
with that,
Are you adding to the steel structure in any way?
no, sir. There might be some modification of the steel structure to reinforce certain parts of it. Maybe cutting through the webbing to allow for mechanical venting and ductwork and things like that.
What about wall lines that don't align with the steel structure?
The which,
Wall lines that don't align with the steel structure, how are you?
okay, we'll let Jacob speak to that.
So it's correct, yeah, the house footprint, does not, align with, structural members, below. So there would definitely have to be some structure added underneath those wall lines. Whether that needs to be steel or wood at this point, we don't know.
That you are adding to the structure.
We would have to, absolutely.
But what I would say is not external.
Right, correct.
So we may throw some essentially more joists in under where wall loads will be. But we're not adding in the sense of expanding it to make a larger porch or something.
To be clear, the idea going forward with the bill would be to clad all of that steel and wood to turn this into a traditional stick-built house immediately. It's gonna have a wooden floor deck, and there's gonna be a wooden house that will build about that.
So when you think about modifying the structure, could you orient me? You said there were 3 sets of pilings 15 feet apart. Like in this drawing from where that.
Sure, yeah, this is really best trying to see, that this drawing over here, which is the site plan. And actually it isn't in the packet. I think there is an existing conditions, site plan that shows a drawing of the.
Yeah, it's called site analysis diagram.
Site analysis diagram.
Sheet number 2.
Essentially, they're evenly spaced, you know, 1 5 feet from the north property line, 1 at the center, and then another line of pilings at the front.
So is there a reason why you couldn't take off the west side, which currently is one of the areas of encroachment in one of the delineated wetlands and is mostly porch? You'd still maintain plenty of square area for your home, because the home is actually nearly aligned.
Well, what you'll see actually is that the next row of pilings is right along the center of this landing right here. So, you know, removing these 3 pilings out here.
Yeah.
You have this whole section of the deck right here, which is unsupported.
So the answer to your question though is yes, you could remove those pilings to the west, but then we have those cantilever beams that are just kind of floating there. We have to add additional pilings to keep those.
Yes, but that could be done with, here, it's a small.
Small, yeah, yes, I'm just gonna read again the comment from the staff report. The presence of the framework provides a limited opportunity to develop the site without greater ground disturbing activity. we thought that's the direction the city would like to see. If the city was like to say, no, we can put up with some temporary disturbance, we'd rather have a smaller deck, you know, et cetera, we'd be happy to come back with some revised designs.
I think part of our concern is that the long-term impact of having impervious structure over the top really does change the dynamics here. So right now, yes, I understand there's been ground disturbance for those piers. But in the long term, covering all of that over creates quite a different dynamic for that whole area. So I think that our thought is, we're trying to understand, I think this is what Jay's getting at too. How much ground disturbance is it really to modify, not remove the current structure so that what is left will be smaller in terms of impervious area?
And gain more for what?
Yes, exactly.
Steve, yeah, the way I would answer that is, you know, I'm not a wetland scientist, I can't measure the cost of taking out a pile and adding a new pile. But I will say, obviously, we were focused on short-term concerns, you know, what's it gonna take to get in there and get old ones out and new ones in, et cetera. Hearing the commission tonight, you're clearly more concerned about long-term impacts as opposed to temporary construction impacts. And we're happy to, you know, adjust the plans accordingly.
Steve, would you have?
Yeah, I just wanted to, voice from the standpoint, we've been talking to the applicants for quite some time. And these are all questions that we posed to them during our discussion, so you just need to be aware that we pointed many of these issues out and told the applicants it would be their responsibility to justify and come in these positions. But just wanted the plan commission to be aware that the applicants were aware of these concerns months ago. And the other point I'd like to make, and it can be during the staff response, should you choose to, I have lots of comments with regards to use of the right of way.
Are there any other questions? Is there anything further you'd like to add to the applicant or the?
Well, I'd like to add something about the eradication of invasive species. I had an interesting meeting with Alton Butler at the site about a year ago. And I wanted to have him examine the piling, examine the foundation, and let me know how he felt about us being able to obtain building permits. And immediately Alton said to me, "You're not gonna do anything until you get rid of these weeds." And I had no idea at the time what it was. There's a huge patch of Japanese knotweed. At the time, it was about 10 feet tall. I had never seen this stuff. I didn't know what it was. And so I talked to experts. I talked to the person that handled it from the city of Cannon Beach, spoke with the clients, and I had several different people, including everybody I just mentioned, indicate to me that the best approach would be to use toxic chemicals. And so I made an important decision at that time not to do that. It is a personal decision that I made, and I was really torn up about this because I thought, gosh, the whole project for me is hinging on this wild little deal, you know, these patch of weeds. But then I did some research and figured out that if I just cut that down and then apply vinegar and salt and then cover the whole area, the rhizome, you know, it has like a rhizome type root ball, kind of like bamboo. I cover that with 6 millimeter visqueen, so it's a pretty big area that I covered, and then I weighted those down with boards, kind of staked those in so that that plastic wouldn't blow around and be a problem with the neighbors. So I did that. It's been about a year now. And what I do is I go back every several months and pull that back, and then I pick at those rhizome balls with like a pickaxe. You have to just it has to be elbow grease. It's a pretty serious deal. And then more salt and vinegar, and then you lay that plastic back over it, and it is really effective. I'm getting a really great result with that. So I'm proud of that. And so that's one way that I'm trying to preserve that sensitive wetland. Then on top of that, we also have quite a bit of the Himalayan blackberry. Really difficult to get rid of, but so I've been working on that this past year. I'm proud of it.
Thank you for not using. Yeah, I think both of us know similar fights. They are.
I would like to hear Steve's comments about the right of way issue, so we can sort of respond to them. Let's say more presented during a staff report.
Really not set up that way. We didn't talk about that before we go through, I think my hunch is we probably won't have that sort of a discussion. Anything further you'd like to add, with what we have covered so far? We'll come back to you, by the way, we will close, before we close the record, we will come back to you, for the final opportunity.
Okay, thank you.
Yeah, you bet. If there's no more presentations at this time by the applicant, are there, are there presentations by proponents? Other people in favor of this? Okay, we'll move to, we have some guidance here, please.
Yeah, sorry. Hi, good evening, my name is Earl Torres, 620 Nicole Park Road.
Sorry.
620.
I missed your last.
Oh, Torgelson.
Torgelson, thank you.
So I actually submitted, some comments,
Oh,
and after hearing everything else, my questions about solar access seem kind of small, but I was wondering if I could ask the design team, just in terms of the design of the building, how do they evaluate, assess the impacts of solar exposure onto my lot, which is directly north?
the way this process is set up, you can ask us,
Okay,
know that we will consider that, and we will give them the opportunity to respond in their final comment. It will not set up for dialogue between parties.
okay, okay.
So feel free to ask it,
Ask it.
and everyone gets to hear your question.
Well, actually, I did ask for that in my, my email.
Yeah.
I did ask those questions.
And may I ask you a question? Sure. And again, this is just so we kind of have some context. I'm not a solar access specialist.
Sure.
But I did visit the site and I considered your concern. And I thought about, you know, if I live in the house, what am I worried about? Where is this going to impact? And I would try, like, I'm not sitting in your backyard, but I did take a good look.
Sure.
You have those trees back there.
Yes.
It seems like if this house is gonna impact you, it's really gonna be in that sitting area, that backyard area. Where you might spend time, probably spend time out during the weather when it's not. Is that your concern about the solar access primarily?
It is in that area.
Okay.
Yes, it is. And, yeah,
It seems to me, and yes, I agree with your comment that the house will be taller than trees. But as I think about the path of the sun in relation to the height of those trees, the majority of, and you know, especially, but the majority of the solar impact is already in place in those trees. There will be maybe a little bit more, but and again, you know, the angle of the sun can change,
sure.
it does change. But as I sat there and I really thought about it, like, I think that is really gonna impact maybe just that skylight. And I don't know that the angle would hit down in the backyard.
The trees are actually about, 12, 15 feet, something like that. So the house is gonna be 28 feet, so it's quite a bit higher.
It had more to do with the proximity, and
Oh,
again,
sure.
the proximity of the trees to where you're sitting, you know, there's that distance there, and I don't know how much, but let's say 15, 20 feet.
It's a small tight area.
Yeah.
For sure. And there's a time of day.
And that's on the southwest corner of your home.
Yes. So,
So the design that's proposed sits further north from your house.
the center of the house, the height, which is the highest part, is, kind of halfway down.
I understand.
Yeah, that's on this.
Yeah, I understand the concern.
Yeah, sure. So, yeah, the trees. So this is the patio area. So the trees end about here. So,
Gotcha.
yeah,
All right, I understand.
yeah. So anyway, I submitted that. haven't been on one of these before, so I wasn't sure of all the procedures.
Sure. Well, I appreciate you coming tonight and know that we are thinking about that public testimony and it means a lot to us, about the way that it's included and really have the opportunity to get them a check. Are there any other presentations by, Hope on at this time? Okay, is there a staff response at this time?
Yeah, only a couple comments with regards to right of way and variances and parking and some of the mitigation efforts. With regards to right of way, the plan commission really only has purview over private property. It's the city council who is the one who takes a look at allowing projects or things like that to utilize city right of way. So when you're thinking about that, if you're considering a parking variance, the options are that you consider no parking on the site, or you consider a variance to allow it in that spot, provided that the applicant gets the required encroachment to utilize the right of way from council. With regards to the mitigation, I would say that falls into similar situations in terms of what we're talking about from a zoning ordinance perspective. Meaning, the mitigation is supposed to be taking place on the private property, because we don't know whether it's engineering or whatever, what concerns they have with rights of way. So we never, as a plan commission, are granting applicants variances or authority to use the right of way with that. That's just not in the plan commission's purview. So it's really important to understand that when we're looking at this, that either condition, if we were to approve this and we're talking about variances, that it's either no parking or it's the parking as proposed, provided they obtain the necessary encroachment. And the same with mitigation. If they're gonna propose mitigation in the right of way, there should be conditions that require that encroachment, because planning commission cannot grant those variances.
Question? Okay, was that you good?
Yeah.
All right. So we'll come back to the applicant. You respond to anything you've heard?
Yeah, thank you again, Joseph Schaefer. And I'm gonna step over in front of a couple of these boards. Number 521 and 6. And I want to discuss the concern about solar access and the solar questions. We don't have a solar study per se. We'd be happy to provide one if you'd like. But what we did is a couple things that are illustrated here. Again, the red outlines are the former house. Okay, so the first thing we did was we moved the house 5 feet. With a couple of small bump outs where the setback is 7 feet. But most of the house is 10 feet, 5 is the middle. So that's the first thing we did. Second, we did that you see more on this north elevation outline. We obviously shrunk the volume of the house. The third thing is we don't have any projections, no chimneys as the front of the house does. This comes at a cost, the cost of the front yard, as Commissioner Olaf pointed out. Hey, we've got this curvy projection on the front that is now in the front setback. That's the cost to the applicant as giving up, more of his front yard. I just wanted to point those two things out. The next thing one of the numbers that we did is we tapered the house. As I mentioned earlier, we're generally allowed 1,000-foot footprint, 2 stories, 2,000 square foot house. Right now, we're I think 1950, and it's tapered. So we have a larger ground floor of about 1,250. Upstairs, a little over 700, it gets us to just under 2,000. So we think by having a larger first floor and a smaller second floor, that not only gives the appearance to people on the street of a smaller house, but it also reduces the solar impacts to the north. And the last thing I'll mention is you can see here on the roof plan, we have ridges oriented east and west with a 10-12 pitch. So on both the east side and the west side of the house, what you see here on elevation 5, that is sloping down toward the north boundary. which obviously reduces solar impacts as compared to a different type of roof shape or roof plane. In terms of Steve's comment a minute ago about the right of way, I agree completely. Very accurate. Again, Mother Nature doesn't respect property lines. And so, we understand that engineers see right of way and have sort of specific ideas sometimes in mind for what they want to do in right of way. Scott has been in touch with the public works people frequently as we develop this design. Haven't heard any objections so far. And, you know, perhaps the way Steve explained it is, you know, write a condition that, you know, mitigation or partial parking in the right of way needs to be approved separately.
Can I ask a question, the designer? Considering the solar issues, is there anything further that can be done with the roof line to further make better solar access for the property to the?
We did look at that. And it seems like the, sort of the biggest impact there on the north elevation is that large gable. The one thing that could potentially be done is to make that a hip roof, instead of gable there. Realistically, it wouldn't be, in keeping with the gables, the rest of the gables around the house, so. So I think that was the reason why we tended toward the gable and that. But other than that, to meet the program that the client had and, we went to great extents actually really to keep the roofs low and steep. Yeah.
I have one more. The prior DSL approval was from 2010. Correct? Yeah, June 19th, 2010. I have to assume that was based on Jay Raskin's plans of 2009.
Correct, yeah.
As the DSL review have you submitted to DSL permanently?
My last bit of interaction with DSL had to do with the new wetland delineation report.
Correct, so they've approved your wetland mitigation.
Correct.
But they have not approved the structure.
They haven't seen that, the new
They have
structure.
not seen it.
Yeah.
And that's, I think that might be a little bit of a rub there.
Okay.
Because that prior DSL approval was based on the frame, based on the structure that exists of the 2009 plan, but not your current plan from 2000.
So they're fully aware of the structure and then, but yeah, they haven't seen the new footprint, the shrunken footprint. But they do know about the piling and the structure and that's about 2,500 square feet. So yeah, I had some correspondence back and forth with them about that.
But they have not seen.
No, but we actually didn't have them at that point in time. I got right into that wetland delineation report, and it was a part of the process I've been going through with Robert and Stephen. So, and I haven't had, nobody suggested that till right now. Is that something you feel like they are gonna want to see that? They didn't indicate to me that they just haven't seen.
Yeah, I would inquire.
Okay, I'll look into that.
So this is a completely different plan, completely different structural systems. We may be covering the same area, but you have different conditions.
Okay, thank you.
I have a couple questions, I think, maybe for Jacob. One, you said you talked to Public Works about the tie into the storm drain system versus, just leaving the, wetlands or the water on the wetland and the buffer zone. Right. Think of the reason for that, has there been flooding on Sixth Street or on Hemlock or,
No, we spoke with Trevor about it, Trevor, Public Works. And just asked a very plain basic question, what are we gonna do with the roof water? And he said, put it in the storm drain. So we told him that there was that, existing extension from the catch basin. And he said, you know, that's the typical thing that they would do, dig that up, locate it, and, you know, run the drains.
Would you put in trenches or would you suspend that from the outside structure?
I mean, I think typically it would be in trenches, you know, because if it were suspended, then it could freeze and.
That's gonna add to,
I'm sorry?
so that will add,
Yeah, so we do have, we indicate, you know, approximately 2 yards of sub-excavation, you know, for that purpose. I mean, there may be, you know, certainly some options of suspending.
Is that catch basin?
Sure, catch basin, site plan here. Show you move in there. Is right here. So this is an existing storm drain line, approximately, I don't know exactly where it is, but, you know, Trevor said that we would dig this up and then connect onto that. But yeah, I mean, you know, alternative options of possibly suspending the lines to avoid excavation and with some frost protection, tree protection, stuff like that, you know, is definitely an option.
I wanted to ask you, would Trevor really be that difficult on this issue or did he just express it?
I would say that it's typical for any remote connected to the storm.
But he's
I mean, that's, you know, so we could have conversations, you know, with them to see if other options, but any type of typical construction, that's personally for.
Except one more wetland or buffer.
Right, I'm just saying, that's typical practice.
Yeah.
I have one more question for you here. So that's got a double gable on the front. It looks like that second gable, yeah, the upper one there. Could that be eliminated, put a straight line to the bottom gable or give a few less feet and height to that center would still maintain the appearance of the gable matching the other gables on the property?
Well, I
I mean,
think
how
that,
much would that give us there,
Yeah.
I guess, is what I'm saying. And
well,
that
a
would be
couple things, I mean, one is that's an attic up there, and that's where the mechanicals, are designed to be located. You know, in a house like this, there can be a lot of mechanicals, so you look for places for that stuff and storage, but the other thing is, you know, reduce that gable, I think that it's important to provide, kind of scale to this house. I think that, you know, the lower gable, what you're seeing there is actually as a cantilever. And so there's a little bit of a bump out there, and so to give this elevation some depth, you know, this here is a cantilever with a lower gable, and so you see this kind of row of beams right here. So that's additionally cantilevered out past this portion of the dining room. So you have some relief here and some additional relief here. And then this is kind of the main body of the house. You can see this is one plane that continues to blends into the dormers.
It's also the front of the house, isn't it? It's the front of the house.
Yes.
It's not facing the door.
Right.
Well, there's a similar.
I don't see it in the drawing.
The back elevation?
Yeah.
It's on this one here. Yeah. So it's this one here. This is the, you know, kind of continuation of that dormer.
Oh, but it doesn't have the cantilever, it doesn't have.
Correct.
Right,
Correct.
doesn't happen.
Right.
The double pitch.
Yeah, that's just more, you know, pragmatic and, simple.
And you can also see the difference here on this next elevation. This is where the lower gable is bumped out on the south side in the front, and then on the back, it just isn't there.
Yeah.
So.
Thank you.
You have there's some really nice 3Ds and things like that that show you, because the rendering kind of shows that.
Anyone else? Okay, anything final you'd like to add at this time?
Thank you for your time.
Thank you. Thank you.
Yeah, thank you very much.
You bet. Close the record, move to our deliberation. You'd like to start?
Well, I would say starting with mitigation, it was helpful to hear that it sounds like they can come up with some extra area, but I would want to see a more specific plan for where exactly that mitigation was going to occur to make sure they offset at 1:1 the entire structure and stair area, et cetera.
Other thoughts? It sounds like a qualified positive. You're qualified positive, I mean, you know, with the right mitigation and.
I am still really worried about a variance for this big a change from the code. The code allows 1,000 square feet, but that's 1,000 square foot coverage for any buildings. We're being asked to go up to 2470.
Yeah.
I don't like the precedent that says. I really appreciate the fact that you're trying to deal with the existing structure. So I'm a little bit torn, but I'm very, very worried that we go that direction, what happens next time when someone comes in and says, well, now I want to build something that's 2470. That's why I was curious about this idea of whether the underlying structure could be cut down enough so that when we grant the variance, it's not more than double, yeah, 3 times, nearly 3 times as much as what's allowed. And I would say, the way the code is written, it's for 1,000 square feet coverage. That doesn't mean you should be allowed 2,000 square foot total. If you made a box, obviously it would, but the code is about the building footprint. So that's where I'm stuck.
I understand that we have authority to make some, or have some letter to give us, you know, here and there. But I'm, you know, that, I can't, I don't know how to.
Yeah, that's a lot of hardscape and, large footprint on that.
Even, well, some, you know, letting water run through this, but, you know, it's 3 times as much as.
Mickey, I don't disagree, but let me run something by you. I mean, this particular house has this particular application. Has a benefit of an exception of construction equipment. You don't have to tear up anything. So, you know, the precedent is, you know, there's really a clear policy that kind of supports us here, and you know, we get this eyesore off the map, we build a nice house. It actually is better than, I think, than going and taking all that out, putting your plans in and just building from scratch.
I'm not suggesting that. What my question would be is there a way to take off just one end of the structure and then, as you mentioned, maybe some less invasive piers or something, but to reduce this incursion into the wetland, I think that's a serious benefit.
Right.
And it does mean that then what we're granting variance for is much smaller. And I wouldn't be expecting to remove the 50 feet underground, but if there was a way to just cut off.
Yeah, realistically, that's never coming out.
Right.
Yeah,
exactly.
but it doesn't mean it can't be cut below a surface, saw cut, and cut off and then covered, you know, it's gonna be there no matter what, but still, the overall disturbance would be less.
And to Mike's point, you know, the planting that they're going to be doing, would, I think, enhance that area more so than what it looks like right now. And eradicating the weeds and, moving the invasive species might actually, benefit the wetland areas, more so than what's going on there right now. I mean, I don't know that for a fact, but I'm looking at the plantings and I'm looking at, or hearing, about the weed removal and, you know, if we can find a way to maintain the water on there and, those 2 wetland areas, rather than just put it down into the storm drain. We could have something there that looks, well, that could benefit the 2 wetland, areas on that property.
But again, I think it's a benefit then having less impervious spaces, absolutely, for our group. But I think it's a beautiful sign. I hope it happens. I just want us to think about whether that could be reduced in size so that the porch basically is removed.
I'm still concerned about the SL, not knowing what it is. For our section,
17-102-0703 or 2, 3. It's placement of fill, it's gonna be filled in this, yeah. And, you know, and they don't have, you know, they can get a no permit required that are from DSL. I just think DSL should be informed of the current plans rather than 15-year-old design.
Other comments, concerns?
What about the variance piece? The parking.
The variance, and that falls into my same question of reduction of the frame. I do understand that there is some slope in there, there will require some fill to be put in there, but again, they have a broad allowance in there. And get that parking on site, it's not a self-imposed hardship, but I like that they're using the existing frame, I think it's a great idea. But modifications to it, I don't think are outside of the design. Because it didn't have to have that site, and they would eliminate that variance. They would also reduce the second variance for additional space. And like I say, I have no problem saying, yeah, maybe we should, you know, move, well, be a little over 1,400, but this is a reach for me. Don't expect any real land from the forest. I'm not saying that I do.
He doesn't, I don't think he does.
No, I'm not saying that we should stay with that.
You know, I'm okay with that. I still come back to, we have a compelling argument that this is very exceptional and that all of the damage is done, and then we say, oh, yeah, that's true, but let's do just a little bit of damage to make it look a little bit better.
It's not just look, think about how much impervious area there would be. I mean, if you look at this site, you have lost an incredible amount of area. So if we could gain back that much area for mitigation, that is a serious benefit. So I don't agree that this is for looks. It's not at all about the looks.
Is there a way to change what the structure is so that it's not as impervious? So
No,
that,
because once you've shaded all of that with porch or house, you've completely changed the dynamics of that area.
no question you change the dynamics. I'm looking to see if there's middle ground on the idea that it is now impervious. So spacing on boards, fascia, on the front side. Other ideas for maybe a middle ground on the idea that that's an impervious surface. And again, I'm not, the only thing that has me much more along the lines of that shouldn't be there is the idea of the variance. But if I put that aside and I just look at this from an impervious surface, I think there's a way that we can consider it less damage.
But when we look at the code doesn't say slightly impervious. The code says no coverage. And so I think that's the concern.
The challenge for me is this is a system that is a very unique position in the city in as much as it was developed under one set of codes. The city moved the code and now it doesn't conform. And so just philosophically I struggle with that. And so I'm going to try to find a way to at least make sure I consider ways to make things that don't work on a strict interpretation possible. They might not have the variance, that's a conversation. Because yes, with that background.
I think my concern with that thought process is that it's not the same owners. It's been 15 years, you know, this is not like, wow, 6 months ago, a year ago, someone started a process and suddenly the code changed on them. This is so long in the past that if we start doing this kind of reach back, like, oh, there should be a right because somebody did something here 15 years ago, we can't ever evolve. It's like, because we get stuck saying, oh, wait, somebody did something.
March of 23 is when we said that. Yeah, or when it started.
Let me ask you guys a question, I mean, the applicant has shown a willingness to consider
Yeah.
changes. I would like us to consider a continuation and a request that goes out through our motion, that they bring in information like what would it take to bring that deck in a little bit? You know, how can you improve the imperviousness of the deck? Can you do something there? Where is your other make it from? And, you know, let's really even it up as opposed to say we're closed. And things like that, and then see what they come back with.
Well, I think the best way to do that is have a discussion. We can't make a continuation. But
One of us can ask for one.
I don't know, that's true, I'm not convinced about that, but we
No,
can
I
voice
just,
it.
can I jump in here? Excuse me, Chair. So this is in the deliberations phase of the process and you're deliberating towards a decision and the record is now closed. And no participant asked for the record to remain open to submit additional evidence.
Thank you.
But we can be very clear about our concerns, and I wrote down a whole list, and we touched on a lot of them. Kind of messaging where we're at, if there's disagreement on something, like, for example, my concern on the definition of impervious. Let's have that discussion and go, okay, I agree, just so we're voicing kind of where we're at. And then move to some sort of a decision after we've had those discussions. I think we've done a pretty good job. The variance, I think we've, Jay, you voiced that pretty well for me. It's a self-imposed need by the fact that that's there, that should be parking, that should be that parking lot. The impervious, again, I'm on the fence on that one, and frankly, I might be trumped by the variance. I think I probably am trumped by the fact, you know, variance can park, probably put that in place. Storm drainage, that's not a big deal, I don't think, although it seems to me we have, I come away with every chance we're in a wetland, we need to be looking for opportunity to put that water in the wetland.
Who would actually said that?
And I don't know why we continue to have this conversation back and forth, as to, anyway, it seems like a larger conversation the city has to have. But I want that water to remain on the side. The idea on the modification, that it seemed like they were saying they were open to that, and I'm hearing them say, yeah, we're open to it too. Is there anybody who's not open to that modification that just wants the whole thing started over?
Modification meaning reuse on the structure.
Reusing what's there,
Yeah.
and, you know, maybe you had said, you know, maybe pull the couple out at the end.
Yeah, but no, we're not saying it should all be taken out.
Yeah, that's what I took away from all the questions is we're all receptive.
How about solar
I
access?
just don't, we don't, yeah, see, solar access now kind of confused me because it's kind of dealt with here in setback. And I mean, these guys are compliant, there's nothing really unique about this house, it's the same height, it's got a bigger setback than is required. You know, I think it's.
If they weren't coming for a CUP, it wouldn't be, sure.
We said again.
If they weren't coming for a CUP, it wouldn't be an issue. 20 foot house would go over there if it was not wetland, and it wouldn't ever come in front of us.
Jay, you mentioned a concern about the curve in the front, pushing into the front setback.
Yeah.
The explanation I heard back, I heard in response to that was needed to offset that solar, to partially address that solar access. Are you satisfied that curve to be inside, or can encroach in the way it does in exchange for the offset in the back on solar access? Or would you be, if we actually do need to have that be another variance?
Was that actually the case?
Burning.
I didn't know if it was the opposite.
No, I don't see that being anything for.
So let's put it this way, if it moves 5 feet forward.
No, it was, because it's only, I think, the pop out, the next to the curve.
Right,
So it didn't change the back at all to do that.
but the whole structure moved 5 feet forward.
Yeah, that was my understanding too.
'Cause I thought they're using an existing frame anyway.
Well, yeah, if you have a subframe, then that's, you're gonna move the subframe.
I see the curve as only being an aesthetic.
I'm saying.
I see the curve as being only an aesthetic, I don't see a reason for it.
All right, you say somebody heard you.
Yeah,
That needs to go.
I think there's no reason why.
You say curve, what are you talking about, Jack?
There's a bow in the front deck that's being added to the frame.
Okay.
And, you know, they haven't, given any information on how that's going to be supported. Yeah, I don't see any reason why I can't go straight across, other than the fact they want a little more room on the deck on the south.
Plus that bump out encroaches into the wetland area.
Additional, yeah, you know, I can buy into the 2 steps on, and see anyway within the 2-foot allowance from property line.
You know, a lot of what we're dealing with here, as you said at the start, is a long house. And they've made some, I think, meaningful architectural. I don't want to say modifications, but I think that they're doing a good job of breaking it up. And one way of doing that in my mind is that bump up. I like it.
But it's just a porch, this issue.
It's not the house, it's the railing of the porch.
I'm looking at the lines. Rather than thinking about the lines. I might not be thinking about them from how I would be sitting, walking by the house or driving by the house unless I had a big 4x4. But I like the idea of breaking that long run out. I'm just voicing that. It was something we brought up. I hate to leave it. Great, which it could be a big deal if they felt strong enough at the time. So, how do other people feel about it?
I think the team said that wasn't to make it.
Oh. What else do we know? Oh, lighting came up. That's a big one, and that needs to be addressed much more specifically than we have here. Now, they didn't, anyone else?
Yeah, we definitely need to see very shielded, dark sky compliant, like.
Especially turn us there. Specifications, please.
The conversation around the right of way, Steve. You mentioned they had been in a lot of conversations with you guys on this.
I would say in terms of a little bit with the parking, a lot of this was kind of a little bit new and modified. I was talking about some of the size of the house and some of the issues that way. We had some issues, obviously, talking about the parking and that it might be better to ask for nothing than asking for, that parking the way it was. But as far as like the mitigation and some of the landscaping, I'd see that some of the application was submitted. And I just would not encourage use of it. But if that's something the applicant wants to choose to do, and if the planning commission would consider it, it absolutely has to be conditioned and the council can deny it. Then you're not moving forward at all.
And all that we're responsible for 2 spots. What happens outside of, and right away is not our privy. So how nice our own concern are those 2 spots, 9x8 on within the property boundary.
You know, that is a contentious issue in the case.
So it's either, in regards to the variance, either we overlook it and say, okay, you don't have that any parking on the property.
I get it.
Or we, after modification.
I would encourage some input on that while they're here, so that if they come back with 0.
Well, I don't really want to, but I will voice again, parking is. I will voice, parking is probably one of the most contentious issues that we have in the city, for us to be, sure, you don't need it for.
As long as the applicant is here, then that's all I want.
Okay.
And then they can justify it from there.
Okay, so that could be. Are there other concerns that people have tonight, if they feel have not been voiced for the applicant to consider when they come? Should they need to come before us again? Okay, I think we've talked about this enough. May I have a motion on this, these 2 items? Use and then request for comments.
I see a couple options, right? There's 9 or septic, right? And I don't think anybody is saying septic. So, is that what people are, is that what we are?
Why don't you make a motion and let's find out.
It's your night, Mike.
I'll do that later.
I might get paid back. I move that we deny this motion.
We have two in front of us here, one variance and the conditional.
The variance and the condition.
Okay, Missy, do you feel like we need any more detail than that for us to move ahead? Would you like additional detail, or do we have enough to go for a second here?
You know, because you're the initial decision maker on this one, I'm less concerned. You're not sitting as an appellate body, so I think you could deny it because it fails to satisfy the criteria. It might be helpful. I know it's a burden, but it might be helpful to articulate in the motion which criteria are not satisfied, and it will give the applicant guidance if they choose to come back. But I know the wetland overlay zone, it has a lot of criteria.
Yeah.
And I know it's late too, so.
I don't want to detail that, good, but would we want to consider opening the record again and allowing for them to. To request continuance.
That is not, that is very not ideal to do that. I mean, I can't stop you. I can't stop you, but I'm just saying it's very not ideal, so.
I mean, some of the things we're asking for here are not, they're not just not to do, it's gonna take a while, so any kind of continuous we even do, we open it, it's gonna take time. We are voicing that we're open to something here, I think we've done a good job of voicing where our concerns are.
So leave it at that.
I think we leave it at that. Okay. So let's do that.
Can I make a comment real quick? One option you have available is deny it based on the fact that not making part of the medium part requirements.
That touches on in one of the two, and.
So, I mean, if you don't meet that,
Then you
can't move forward.
Okay, so what, that touches on the variance, what about the conditional use, what can we say to that?
Well, it fails to comply with the requirements of the wetland overlay code for lawn coverage.
Do you want to move under?
No, I think I'll withdraw mine and let it make.
Yeah.
Sorry.
They move exactly that we deny, this is the number on this. Okay. B 2502 and CU 2504, on the basis that the CU 2504 does not comply with the wetland overlay zone requirements regarding building coverage, and for B 2502 on the basis that the parking is not within the property.
Did that, and again, I'm in another time frame here, did you say, the first one you said was C 2504, or the second you said it's 2502, did we do that? Okay, we good, go ahead, second.
Second.
Any further discussion? That's what we call the roll, please.
Commissioner Moore,
Yes.
Commissioner Sinclair,
Yes.
Commissioner Matusek,
Yes.
Commissioner Orloff,
Yes.
Commissioner Bate,
Yeah. Yes.
Commissioner Wade,
Yes.
Chair.
Yes. B 2502 and CU 2504 are denied. We have one more item here tonight. I am going to take a 5-minute break before following at 9. On our last consideration. The time extension request, these ones. There it is. We have 2502. Oh, 24, please. It's the light in here, I can't read. I'll blame it on that. Okay. In 2402, J. Roll, half of Ron Miller Properties LLC for an extension of the roof variance permit. Time extension request, actually, Steve, I'm serious, for anybody listening, fix that, I do have a hard time reading.
It's, yeah, I kind of said,
Yeah.
I don't have any control, so, there's a paper, I'll get right at it.
Oh, actually, now that I put it up, okay. I'll just figure it out. 24th of Jero of Tulsa Design LLC on behalf of Normal Liquor Properties LLC, requesting a time extension to obtain a building permit for the previously approved variance to setback requirements at 132 North Large Street, tax 4605 map 51019 DP in a residential high density R3 zone. The request will be reviewed against the criteria of the municipal code, chapter 17.64, setback reduction, 17.90 variances and time limit for approval setback reductions found in section 17.64.141. Does anyone object to the jurisdiction of the planning commission to hear this matter at this time? Does any commission member believe he or she is in a conflict of interest or personal bias?
May you present me?
You're supposed to wait.
I'm sorry.
Come on, man.
Second on the fine.
Ready to go. I want to really. Has any commission member had any ex parte conflicts or made a site visit? That's right, yeah. Maybe that's that.
Hey, Robert, I'll take this one. I think the applicant will be able to explain the project a little bit if you'd like. There's a little bit in terms of their time and what the project is, but they're asking for an extension in time. Staff is not objective.
Okay. Any additional correspondence? No. Okay. The public testimony. The pertinent criteria to be considered are noted in the staff reports and listed on the criteria sheets on the meeting page of the city's website. Testimony, arguments, and evidence must be directed toward those criteria or other criteria comprehended in the North Municipal Code, which the person testifying will reply to the decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue precludes appeal based on that issue. Prior to the conclusion of the initial evidentiary hearing, any participant may request an opportunity to present additional testimony, arguments, or evidence regarding the application. The planning commission shall grant such request by continuing the public hearing or leaving the record open for additional written testimony, arguments, or evidence. Persons testifying shall first receive recognition from the chair, state their full name and mailing address, and if appearing in a representative capacity, identify whom to represent. Is a presentation by the applicant.
Yes. Jay Orloff, Bohan Design, representing Drum Heller Properties. V2 24-02 expires on the 29th of this month. We are ready to submit. Plans will be going in next 2 weeks. We only request an amount of time reasonable for an extension. I understand that typically it would be another year, but we do not need that. So we're ready to go. We just have run out of clock on our various requests.
Are there any questions for the applicant? Anything further you'd like to add?
Unless you have any questions.
No one else, okay. Are there any proponents who are online devices? Are there any opponents? Final? Nope, okay. Staff?
We don't object to the request.
Then with no further statements from the applicant, we'll close the record and move to our deliberation. Does anyone have an objection to this request? No, may I have a motion? And then we approve this request. Second?
I'll second.
Further discussion? That's what we call roll.
Commissioner Matusek,
Yes.
Commissioner Moore. Yes. Commissioner Sinclair,
Yes.
Commissioner Wade,
Yes.
Commissioner Bates,
Yes.
Chair Newton.
Yes. Request for extension time. Thank you. Let's move to informational items, starting with tree report.
You want to take this one, Robert?
What's that?
Go ahead, I'm sorry.
Oh, yeah, I got this one. Unfortunately, I can't stream it over. I'm kind of working off 2 computers here. But during the month of April, a total of 7 trees were removed. All 7 trees were hazard. There was a required replanting of 3. The reason why the other lot did not have a required replanting is due to its size. It was a very large parcel just kind of northeast of the RV park. So due to the size and density, there was no requirement to replant trees.
Questions? All right, we'll move to the good of the order. Do you want to have anything for the good of the order? Update on, my word, being a little jumbled here this hour for me. We talked a little bit about, process for our record. And you guys coming back to us at some point, not a hurry, you know, you guys have a lot going on right now. Any update in terms of where you guys are and in terms of coming back to us with some kind of update?
Nothing to report at this point in time. We'll have to bring that back, and I'll work with Melissa. Again, I don't know if there's something you want to share as far as specifics.
I think as I recall, what we've talked about is us not getting understandings of how information is cataloged when it comes to you, and maybe us unifying in terms of just an understanding this body in particular, unifying or having a collective understanding how that information is cataloged. In particular, again, I'm rambling a little here. In particular, when we get these big packages, what we're trying to do is make sure that we're not having to go through that whole thing again, and we just get the new information, so that if 2 months before we had a whole set of similar information, and we know how this exhibits read, and we know how you guys put them in there, and what the process is for the when, and even timestamp or what have you, then we don't have to go back through that. But there's been a few instances where we said, oh gosh, did we miss that? Did someone slip it in? The one I'm thinking of where someone slipped it in, or that they recused that was years ago, before anybody here was on city staff or on the planning commission, but it has happened. So with an understanding of how that works, communicating to us, we'll all be able to move more efficiently through those packages and feel more confident about our reviews of those. I think that's
Melissa, do you have any comments on that? Because I know a lot of times there is a significant amount of information that comes in, and it's, you know, it's almost, I understand completely what you're saying, because we get it, and it's like, what do we give, what do we don't? And at the same time, I'm always worried about the record and someone saying that something isn't in it. I don't have a great answer. Stuff comes in, we put it in the record because they want it in there, and we keep doing it kind of meeting to meeting, and I mean, I guess, like I said, you and I can talk about that, but I don't know. I guess I don't know what's my answer.
I think we could, well, the question is to follow you.
Is this question to me?
Well, I think it could be followed, but yeah, you got the mic, if you're ready for it, go ahead.
I'm just having trouble hearing is all. I'm not at all wanting to jump in.
I think this question is process. I think this is a process driven conversation. In terms of, there's just a massive amount of information put on city staff, and the city staff is then responsible for getting to us, and we're responsible for saying we've read, and we're trying to figure out how to manage this process, which in the world we live in is really hard. There's just a ton of information being put forward by really savvy applicants and their advisors. So you know, maybe there's some best practices you've seen in some group in terms of what they do to manage it, or maybe it's just doing exactly what we've been doing. But I think for me, where the conversation starts is, let's just calibrate and make sure we're all on the same page relative to how we understand what we're doing. So while it might be imperfect, at least we all understand the imperfect we're working.
You know what, there's a few things that I can suggest. One is, if there's any way, when doing the packet, if it could hyperlink to right down to the page, take the agenda and hyperlink to where in the packet that part of the hearing starts. I think that would make the packets not feel so big and overwhelming. And that's one, I say this as a non-tech person, but I think it might be fairly easy to put hyperlinks in the agenda so that you can jump right to the part of the packet that is part of the hearing. Then it doesn't seem like you just read the same 500 pages. And then the second thing is for the serial hearings and the applications that are very complicated, it could be, I don't know if it would be simple for staff to, put something at the top that says something like, previously presented at the April 22nd Planning Commission meeting, so that it kind of flags for you all that you've already read this and you don't have to go back and reread it. So there's a few ways to maybe, tweak it so that it flows a little bit better. Those are my two off the top of my head.
One thing for me is I think about just the way I go through these packets. I think that live suggestion would be a good one. Often it's just PDF, if they're really big. And, my assumption, and again, I don't know I'm correct, is 1 was the earliest and 3 is the later, but again, I always assumed that, and I haven't done that. So 2 things: 1, it might be a meaningful change, and 2, just if I'm right, let's verify that's how we do it. I think that's the theme of it. A couple ideas we shared here tonight, would help me move more efficient with those packages.
One thing, I don't know, we can consider this or not, but even the highest court in the land limits the amount of data that they receive from any applicants or applicants. I mean, I'm not saying that we leave out any pertinent information, but I am saying that we need some concise, things to be more concise sometimes, maybe. Supreme Court only allows a certain number of pages and, there you go.
It's a little different.
It is different here, I understand that, but I also think that sometimes there's a lot, it's almost like an avalanche, and is it really? I don't know, I can't point to anything that has been pertinent in some of the documents or in the documents really, but, it would be nice to have concise points made and,
What I've heard on that in the past is the second you say you can't submit something, that's the one thing they grab. They will, they limited us. And the other is because there's this potential they're gonna go to another body, they want to throw everything in there because they want to be able to come back in records even in some cases, on the off chance they forgot. They're gonna err on the side of, let's just throw everything for the kitchen sink in, and that we're safe if we end up in larger bodies, because we are poisoning the record. Just a thought. No,
Yeah, we're against land if we don't include someone's stuff.
Yeah. Anyway, I just think it's the kind of thing worth coming back to, because these, in my tenure, whatever that is now, 7 years, I have progressively seen them get bigger and bigger and bigger, and that's not gonna change. But what we can do to get more efficient in our end, so we don't get overwhelmed by that process. So we'll just keep coming back to it, something happening tomorrow or next month, or there's something I think we do need to come full circle. All right, next. So once in a while, we all individually have private conversations, and the public will come to us, and once in a while I have it's brought to my attention things that are on the mind of people, both here in this body and in the public. We're on video, and so our meetings are in perpetuity. Wow, I got that word off. I'm in another time about that. I was gone. So this is my 2 in the morning. So Jay, you are a valuable asset on this team, and I am better for you with it. But that said, when you were appointed, there was a lot of conversation about the potential conflict of interest. So what it has done, what I'm being faced with more are concerns about that potential conflict of interest, or brought to my attention. So I think in order to continue to allow us to have such a valuable number, we have to have the conversation, about how we act, to continue to be as good a body as we can. So I'm gonna be specific. Last week, when you made the presentation that you did on last month, when you made the presentation that you did, great job, I said it at the time. I should not have said that. It voices because I don't typically say it to applicants. I don't typically say, hey, great job, you really set the bar. That's a mistake on my part. That's on the record, and now people can come in and go, well, you guys are on the take together. We're not, I've been part of my own stuff on the panel. But it's real tough to argue with what's sitting there where I say, great job. I don't know how in depth I got on that. Conversations, side conversations, with an applicant. I just think the optics have to be, especially when we're in the room together, they have to be so tight, tighter than normal. Or it's gonna put us into an awkward conversation, one that I frankly just don't wanna have to have, any more than this. Because you are such an important part of the team and you just add such depth to the conversation. But it is gonna require a standard that's higher than the rest of us are up to. 3 times tonight, we had conversations involved around your impartiality to past involvement. And that is always gonna catch the attention of people who are already wound tight on a number of other issues in the city and the country and the world, you name it. We don't need to get on their radar. And I'm only gonna point to me, my comment to you that you did a good job of it, great way to get on people's radar.
I understand. And that's why I'm taking as many steps as possible to try to should not put us in the crosshair. The tree, for example, for that, I totally stepped away from it. I didn't have to, but I did because I thought it would be in the best interest of this community to do so. I do understand that I will have to step on the other side of the diet to do what I need to do. But, looking at, things like, Fidelis before I even got here, I had no control of that. The one that we just, for the extension was also before I came to the committee. I am wary of that, and I'm wary of the number of jobs that I'm taking currently. To try to limit that necessity for me to step away from my position here.
Yeah, and I think it's mostly these are the informal conversations that maybe are more the issue, because you have done such a good job with the formal conversation. But what's the optics of commenting on how you did in your backup on this side?
And
You shouldn't be having that conversation as a commission.
And
So I think that's where we have to be part of, you're doing your job.
Right. Well, and I don't expect that from you in any way. I'm on this side, I'm this person, on that side, I'm that person. And I try to keep myself separate in those ways, but understanding that I do have the crossover that I need to be aware of. And it does affect my professional relationships, and I keep that in my mind all the time. Because there's nothing more that I like to be.
Well, you said you don't expect it of it. We will expect it of ourselves. We have to. So it is, by having you on this commission, by me saying how much I appreciate being on the commission, I have to hold myself and ultimately all of us to a higher standard for that, or it just doesn't work.
I understand.
If anyone else has anything to add to that, I think we've said enough about it.
I think he does a fantastic job, and I think what you're doing in terms of putting stuff out there at the beginning of meetings is exactly what we should be doing.
Anyone else want to add to this, or are we done talking about it? Good. Anything else for good of the order?